1 second. 1 second. 1 second, Mr. Abha. Let me just settle down. Sorry for being 5 minutes late. I had doing some work. Huh? 12. Yes. You are? You have been replaced. You are now newly engaged. Mr. S.S. Rabhana. S.R. Mr. S.R. Rabha, Learned Counsel for the petitioner, submits that he has been newly engaged to represent the writ petitioner and accordingly seeks 2 weeks' time in the matter. Prayer is not opposed. Huh? Prayer is not opposed. List after 2 weeks on a date to be fixed by the registry. Yes. 13. 15. Any who is appearing for the respondent? As prayed for by Mr. Ardhor, Learned Standing Counsel, Tribal Affairs, with consent from the Learned Counsel, with consent from Mr. B. Purkastia, Learned Counsel, appearing for the writ petitioner, and Mr. R.P. Sharma, Learned Senior Counsel, appearing for the respondent number 7 and respondent number 14, relist after 2 weeks to enable the respondent to file affidavit in opposition in the matter on a date to be fixed by the registry. Huh? Why? He's on? He's on leave. He's on leave. You are for the? Have you taken in consent from the petition appellant? No, that will not do. You inform, and then when the matter calls, we shall accommodate. Yes, next. You wait for the matter to be called, ma'am. Don't leave. And counsels, please don't make any mention before this court without informing the other side. I do not want these protocols to be just brushed aside. They are very important. Please follow them before you make it mentioned in this court. Yes. 20? 27. You want how much time? 2 weeks time for what? Or you want to file an impleading? You are for the petitioner. As prayed for by Mr. A. Borough, Learned Counsel, appearing for the petitioner, relist after 2 weeks to enable the petitioner do the needful in terms of the new incumbent to the post of the contemptor number 2. Yes. What do you want in 25? You are for? As prayed for by Mr. P. Bordeloy, Learned Counsel, appearing for the respondent with consent from the appellant, relist after 2 weeks on a date to be fixed by the registry. Item number? 44. You are, Mr. Ajad, you are for the respondent in the applicant. And who is there for the any objection? No, who is making the prayer? What do you want, Mr. Ajad? So you file your objection as prayed for by Mr. A.K. Ajat, Learned Counsel, appearing for the respondent, relist after 2 weeks on a date to be fixed by the registry to enable the respondent file objection in the interlocutory application. You make the correction whatever is required if it's permissible. Yes. Call for. All right. Rupak, একটু call করাই দিব. This is that contempt matter. Yes. This is kept for dismissal. So be there when the matter is called. We'll see. Yes. Yes, Mr. Chaudhary, you have filed the interlocutory application. How much time? But who has filed the interlocutory application? You have filed.
Yes.
Stay vacating. Alright, you file whatever you want to file. I'm posting it on Wednesday.
Yes.
Today is Friday. Next week Wednesday. No further time, Mr. Chaudhary. As prayed for by Mr. K.N. Chaudhary, Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. D. Das, learned counsel for the respondent stroke petitioner, seeks 2 weeks time for you. 1 week time for filing objection in the interlocutory application for vacating the stay. Mr. P. Nayak, learned additional advocate general, opposes to the said prayer. In view of the above, a last opportunity is given in view of the above. Relist on Wednesday, give the date on such and such date to enable the respondent to file objection affidavit as prayed for. However, in the event no affidavit is filed by Wednesday, the matter shall be proceeded in accordance with law.
So,
For impleadment, for impleading whom? The new incumbent. New incumbent. Mrs. Sekar, new incumbent. Oh. Who are you appearing for, Mr. Das? Central government, anyone is there? You won this respondent number 22. This is an impleadment.
They are not responding to the.
But in this impleadment, before impleading, notice is required. Correct. Heard MS N. Saikya, learned counsel for the applicant, also heard Mr. S. Das, learned counsel, appearing for the respondent number 1. No objection, right?
no.
The instant application has been filed for impleading the Secretary, Ministry of Commerce and Industry, Government of India, as respondent number 2 in the accompanying contempt case, contempt case C number 684 of 2024. Stop. It appears that the connected writ petition IWPC number 6036 of 2023 was disposed of by judgment in order dated 23/6/2022 directing reconsideration and release of the entitlement of the petitioner stroke applicant, taking into account the stand of the department without any further delay. However, since the outstanding dues were not released, the present contempt petition, the accompanying contempt petition was filed. However, while filing however, uh, during the pendency of the contempt petition, comma, the advocate learned counsels, the learned counsel appearing for the contemptor respondent submitted before the court that SLC has approved the necessary amount and the proposal has been sent to the Secretary, Ministry of Commerce and Industry, Government of India for necessary approval and release of the sanction amount. It appears that though the state, it further appears that since there has been no communication made by the Government of India to the state authority, despite the state authority has written several letters for release of the amount, the present application for impleading the Secretary, Ministry of Commerce and Industry, Government of India has been filed. Yes, where is the impugned order? Was central government a party in the writ petition? Show me. Where is the order? No, that order is not in your eye. Contempt khan diyak. Page 15. They are number 1. This is the WPC 6036, na? It appears that the Union of India represented by the Secretary, Ministry of Commerce and Industry, Government of India, New Delhi, was an arraigned respondent in the original writ proceedings. That being so, the presence of the Union of India, the presence of the Secretary, Ministry of Commerce and Industry, Government of India, is essential and is necessary and essential for effective adjudication of the contempt of the instant contempt petition. Accordingly, the Secretary, Ministry of Commerce and Industry, Government of India is impleaded as respondent number 2 in the so-and-so contempt case. Give the number, huh? Stop. Application stands allowed. Let an amended cause title be submitted before the registry for doing the needful. No, that first you amend. You have to amend the cause title only then. In the contempt petition, you say that upon submission of the amended cause title, let the matter be placed before the bench for orders, for necessary orders. Yes.
Item number 3.
Similar. Same. This will be also same, huh? Khali here, arrayed respondent number 3. But Miss Saikya, in the first one, you did not get that secretary by name. You have to implead. Where is the name? In the first one. In the first one, the name is there. Instruction, sir? I think I didn't get the name. Marsha, you have to write the name, huh? In the second one, Mashwai, here he will be impleaded as number 2. Okay, the detail is here. Dr. Lakshmanan, secretary. Is the writ petition number is same, na? Is different. So give me those dates, otherwise it becomes difficult. I don't have it to debug. 1 second. Huh? Kodok. Why have you come so fast, OP? Wait, just wait. I should just have a look at the name. Rupang, eto teketok didiok. This is in the first case, huh? Second case, I think better I dictate or what? It'll be better, no? Just see. Diok. First one. That flag mari diok or highlight kori diok. Second one, okay? This is item number 3. 1 second. A contempt condit hobo. Heard MS Ensaikya, learned counsel for the petitioner, also heard Mr. S. Das, learned counsel appearing for respondent number 1 and 2. 1 and 2. By way of this contempt petition, sorry. By way of this application, the petitioner is seeking impleadment of Dr. Lakshmanan, Secretary to the Government of Assam Industries, Commerce Department, Assam Secretariat, Dispur, Guwahati. As respondent number? Huh? The name given here is Lakshmanan. Acha. Where is this guy's name? Page 17? Oh, sorry. Page 3. Sorry. Sunil Barthwal, Secretary, Commerce Secretary, Ministry of Commerce and Industry, room number 143, Vanijya Bhavan, New Delhi, 110001 as respondent number, as respondent stroke contemptor number 3. Okay. It appears that by way of WPC 6216 of 2023, the petitioner sought payment of the entire subsidy amount, which this court, by judgment in order dated 18/10/2023, was pleased to direct the respondent authorities to dispose of the representation and pass necessary order as to the grievances of the petitioner in writing within a period of 1 month from the receipt of the representation. However, due to non-disposal of the representation as well as non-payment of the subsidy, the instant contempt petition, the accompanying contempt petition has been filed. It appears that during the pendency of the contempt proceeding, the learned counsel appearing for the contemners submitted before this court that SLC has approved the necessary amount and the proposal has been sent to the Secretary, Ministry of Commerce and Industry, Government of India for necessary approval and release of the sanction amount. It appears that despite several letters for release of the aforesaid amount being written by the state authority, since no communication has been made by the Government of India, the present impleading application has been filed for impleading the Secretary, Ministry of Commerce and Industry, Government of India. Stop. It appears that in the original writ petition, writ petition page, the secretary. Where is the secretary? Is not a party, is a party. Yes. The secretary, so and so, is was a party, was a arrayed respondent number 4. That being so, the presence of the so and so is necessary and essential for effective adjudication of the contempt petition. Accordingly, the application is allowed. It is provided that Shri Sunil Barthwal, Secretary, Commerce Secretary, Ministry of Commerce and Industry, room number 143, Vanija Bhavan, New Delhi 110001, be impleaded as respondent number 3 in the accompanying contempt petition. You say a contempt so and so, huh? That case number. Let an amended cause title be submitted before the registry for doing the needful and disposed of. Same, huh? In both the contempt, you say that upon filing the so and so, let the matter be placed before the bench for further orders, for necessary orders. It will be listed once you submit. Then registry will thereafter list it. You don't have to mention, Ms. Saikya, I have already given that direction in the main contempt also, that in view of this order, say in view of today's order, once you submit, registry will thereafter, on a date to be fixed by the registry. Yes, interim. When I saw you standing, I knew that that is why you are standing. Mr. Gogoi is laughing. It was his suggestion. Interim, if any, shall continue till the next date of listing in item number 1. All right. Yes, now call OP.
Item number 4.
Impleadment. New incumbent. Any objection? Disposal. Heard, Mr. J.U. Ahmed, Learned Counsel, appearing for the applicant. Also heard, MS. The R.B. Bora, na? R.B. Bora, Learned Counsel, appearing for the respondent number 1. By way of this interlocutory application, the applicant is seeking impleadment of the new incumbent opposite party number 2. Where do I get the details? Where do I get the details? Yes. I, Shri Akashdeep, IAS, Principal Secretary, Boroland Territorial Council, Bodofa. No, how do you pronounce this? Nagar, Kokrajar, BTAD, Assam, PIN 783370, S, Contemner, stroke respondent number 2, in contempt case civil number 720/2022. It appears that during the pendency of the contempt proceeding, the contemptor number 1, I. Anurag Goel, IAS, Principal Secretary, BTC, he got transferred, has been transferred from the post of Principal Secretary, BTC, and in his place, Shri Akash Deep IAS has joined as the Principal Secretary, BTC. Stop. That being so, it is essential, it is necessary and essential to just write this also. It further appears that after the new incumbent joined the subject post, the petitioner, the applicant on 28/2024 submitted a representation along with the judgment and order of this court dated 25/2/2022, passed in WPC number 1283 of 2022, requesting him to release the due amount in terms of the aforesaid order dated 25/2/2022. It further appears that despite the representation being sent, the aforesaid the order of the court has not been complied. It appears that the new incumbent is required to be arraigned as a contemptor in this contempt proceeding. Accordingly, the impleading application is allowed. It is provided that give everything, that so and so Akash Deep IAS be impleaded as respondents within bracket contemptor number 2 in contempt case C number 720/2022. Let an amended post title be submitted in the contempt petition so and so through the registry of this court, through the registry to the registry for doing the needful. In the contempt, you say, upon in view of the order dated so and so, upon receipt of the amended cost title, let the contempt petition be listed before the bench for doing the for passing for necessary orders.
What definition, number 5?
Mr. Manan, that bail is there today. Oh, I thought because generally whenever you are here, you come with one of those NDPS 22-2 bails. I know that. I know that, but otherwise in this court, yes. Yes, Mr. Gogoi, where is your counterpart? Huh? Is it? Last two occasions, they have not appeared. What about on 19/7? 19/7, the yes, that time also none has appeared. Dismiss it for default then.
14 matter.
Huh?
It's the 14 matter.
Yes. None appears for the petitioner on call. Mr. B. Gogoi, learned, sorry, D. Gogoi, na? D. Gogoi, learned, you're appearing as?
Standing council.
Standing Council,
Standing council, environment for. Yes.
Standing Council, Environment and Forest. And Mr. S.S. Roy, Learned Government Council for respondent number 2 and 6. And Mr. A. Bhattacharjee, Standing Council Revenue. Standing Council Revenue. It appears that there has been no representation on behalf of the petitioner since 19/7/2021. Full stop. It appears that on 19/7/2021, 24/8/2021 and 24/5/2022, when the initial writ petition was listed before this court, there has been no representation on behalf of the writ petitioner. It further appears that this court, by order dated this court on the last date of listing, i 24/5/2022, upon observing that there has been consecutively no representation on behalf of the writ petitioner by the engaged counsel, directed no sorry, OP, it appears that, just delete that last paragraph. It appears that on 24/5/2022, when the matter was last listed before this court, upon being informed by the bar, upon being informed at the bar that the learned counsel for the petitioners has since been appointed as a member of the Foreigners Tribunal, adjourned the proceeding for 6 weeks to enable the petitioners to make alternative arrangement in the matter. It further appears that the registrar judicial was also directed to intimate the petitioners as regards the said development. Office note dated 23/5/2025 indicates that the communication indicates that in pursuant to this court's order dated 24/5/2022, a communication was sent to the petitioner. How many petitioners? 123. To the petitioner numbers 1 to 123. However, the communication made to petitioner number 38 has been received back with postal endorsement within quotes, no such addressee RTD to sender, and the same full stop. However, neither wakalatnama nor any communication has been received from the rest of the petitioners by the section till date. But this communication have been received by the petitioner or not? So what is to be done then? It is communication or regita code as a flag kita. Part 2 file ase. Keneke pathaisle communication kita. No, because you can't keep this. The rest, it appears.
Correspondent is lordship, everything the hospital, the addresses are very vague.
No, but then what is to be done? You can't keep this matter pending. What is the issue?
Their lands were taken by Kalidag for 6 additional Kalidag of job.
Can the jurisdictional police station find out?
I don't know the postal record of the registry.
There's nothing available. I may say that, but because otherwise I was thinking of dismissing it. But it looks like there's a judicial order by which they were informed. Now, this advocate also, because of his assignment, has gone.
They're telling me in action up to 1999.
That is understood, but
Set a reminder. Last opportunity.
reminder, it will again not come.
Was-
It further appears that there is no noting of the registry as regards the faith of the communication sent to the rest of the petitioners with the memo number HC capital, Roman 22-1090/WP dated 10/6/2022 to memo number HC 22-1214/WP dated 10/6/2022. This you'll get in this office note, page 3. Let registry verify and place a detailed report as regards the said list after 2 weeks on a date to be fixed by the registry. Let's see what registry have to say.
6 and 7.
Illegal construction. Yes. 16. Yes. However, in case of the application for such settlement made by the petitioner, it is the stand of the respondent that there is no record pertaining to the status of the land covered by duct number 100. The specific stand of the respondent in the affidavit is that the circle officer, vide the letter dated so-and-so after inquiry, had stated that there was no survey of so-and-so village and the nearby so-and-so, therefore duct number area could not be identified. Now, it is not understood as to how from the same duct number 100, the petitioner was given a settlement. Mr. Goswami, learned government advocate, shall receive instruction. Further, circle officer Dispur shall also submit a report. Yes. Report and instruction as regards present status of the constructions made over the plot of land of the petitioner.
Now the construction is basically broken. So there was to see whether it is already broken. The second part is with regard to the geological survey and the patta given to the neighbor. It's a next door neighbor. I have applied for patta and he has also. He has been given patta and I.
That you have not been given patta.
Now they say there is nothing of it. There is no demand.
How then how the neighbor was given patta?
And now what is that? When I came before this on report, they also made issued an order for eviction. That has been stayed by an officer. I'm not on that. Now the question is, if that is the question posed by the
Yes.
report, now they are saying correct.
Why? Huh? What instruction not received? This order was passed long back. After that also the matter came on occasion 21 August 24 and November 24. Now we are almost in June 25. From the last order, it's from the main order, almost a year. That's 16. Which was that order, Mr. Manan? 16 August. Almost a yeah. weeks? All right, we'll give you 2 weeks, but ensure.
Good.
Otherwise, persons of concern will have to come and explain in person. Because you are issuing patta to someone for the same area, immediate neighbor, and then you are taking a different stand and everything you are saying is not there. If not there, then how did you issue patta? On the face of it, it is sounding very arbitrary. Heard Mr. Y.S. Manan, Learned Counsel, appearing for the petitioner. Also heard, yes, you want to say something? No, Mr. Manan, you are in 7852. 7852. And Mr. Correct. Then you take these two together and you first say Y.S. Manan in WPC 7852-2018 and Mr. M. Chaudhary, Learned Counsel, appearing in WPC 4591 of 2016. Also heard Mr. S.S. Roy, Learned Counsel, appearing for the Learned State Council, appearing for the state respondents. Mr. So-and-so, with profuse apologies, seeks a further 2 weeks' time to furnish the instructions as called for by this court by order dated 16/8/2024. Stop. By way of a last chance, the matter is directed to be posted on such and such date, 2 weeks from the date above, by which date, if the instruction as called for is not placed before this court, the matter shall be proceeded in accordance with law.
23rd. Item number 8.
Yes. Mr. Roy, I think affidavit you have filed. How much time? Huh? Yes.
To suppose that question, I have two numbers of one is one.
All right, but the returns has to be completed. Now, I understand it's an old matter. However, we will give them a week's time. If they do not file their return by the time that is given to them, then this court will proceed it in accordance with law. Yes. Your name? Heard MSJ Bejborwa, Learned Counsel for the petitioner. Also heard Mr. S.S. Roy, Learned Counsel, appearing for the state respondent, and Mr. D.K. Mehdi, appearing for respondent numbers 5 to 12. Mr. Mehdi seeks accommodation for filing affidavit in opposition in the matter. It appears that this matter has been pending since the year 2016 and on numerous occasions, time has been granted to the private respondents to file return in the matter. However, considering by way of a last chance, the private respondents, right? The private respondents are given 1 week's time to file their return if they so desire, failing which the matter shall be proceeded in accordance with law. A list after a week and a date on such and such date.
Item number 9.
Yes. Yes. What affidavit was required? SBI, clarify the matter. Has that affidavit come? Yes, SBI? Where is SBI? Who is appearing for SBI? Datta. Mr. Ashish Datta was there for SBI Standing Council. No, I am not asking about NABARD. I'm asking about SBI. I understand you are not appearing for SBI. Yes, where is Mr. Datta? You wait for some time. Let us have him. You can send a message to his juniors.
Item number 10. Cancel.
Yes, Mr. Roy.
Just come after the docket.
He also not very complete.
2 weeks time. 2 weeks. No, no. You have not made BTAD a party.
Cancel.
All right. You think it is not necessary? This court is not going to impose. But tomorrow, don't come and say, now we need to. So if you have to, you see, yes, you therefore, I'm not saying anything today. So that is why I have given him the opportunity. Otherwise, that it can be later on dismissed for non-joinder of necessary parties. So if he wants to take that risk, let him take. Yes. Heard Mr. P. Chakraborty, Learned Counsel for the petitioner. Also heard Mr. S.S. Roy, Learned Government Counsel, and Mr. A. Bhattacharjee, Learned Standing Counsel, Revenue. So both respondents are going to file. You are not filing. No, but Mr. Roy. Okay. Mr. Roy seeks a short accommodation for obtaining instruction in the matter. It further appears that though the matter pertains to a BTAD area, BTC is not made a party. Mr. So-and-so seeks an accommodation in order to obtain instruction in this in order to obtain instruction and do the needful in this regard. List after 3 weeks after the date, list after 3 weeks on a date to be fixed by the registry to enable the learned counsels appearing for the parties to do the needful in the matter.
Number 11.
Yes, Mr. Goswami was supposed to obtain instruction. Yes, if you do not submit, then how will they? You submit. Can it be disposed of? Huh?
He is not entitled to
He's not entitled.
No.
No, but if he is not entitled, why are you not filing your affidavit? What instructions you have got?
Because since the vehicle is identified, therefore we can seek remedy under Motor Vehicles Act.
Which is the judgment?
This is 7W.
You have a copy? It's not here.
No, that's different. That's different.
How do you expect that to be in the court, Mr. Vadajaji? You want to rely a case, you assist us. You give us a fresh copy. I can call it up after some time. You can, in the meantime, you wait. Let us see what is this case. You give a copy to that to the council also. Yes, Mr. Gupta. Huh?
Person and retired government officials. The amount from their account is siphoned off into a fraudulent transaction. And we have approached the ombudsman under the ombudsman service. But the ombudsman has not decided the matter as following law. And rather, on one hand, the ombudsman has dealt with the matter on merits, but in the concluding part, says that it's
Matter perhaps needs to be heard. Pleadings are completed. I'll admit it. No, this matter will have to be. So many affidavits are there. It is not a no, issued for you. All issues will be small. Heard Mr. H. Gupta, learned counsel appearing for the petitioner. Also heard Mr. K. Das, learned counsel appearing for respondent number 4 and 5, and Mr. P. Hajorika, learned counsel appearing for respondent number 1, 2, and 3. So everybody is represented. Now, what about 6? And Mr. N. Goswami, learned government counsel for the state respondent number 6. Only 6 respondents? It appears that the pleadings are completed. The matter requires full-fledged hearing. Admit no formal notice in view of the parties being represented by the respective councils. Post for hearing in the month of when? No, you are getting a fixed month. You're getting a fixed month. Now ask, huh? No. September on a date to be fixed by the registry. Yes. Mr. Banik. Heard Mr. S. Banik, learned counsel appearing for the petitioner. Also heard Mr. T. Buragohai, learned counsel appearing for respondent number 8, and Mr. K. Gogoi, learned you are appearing as learned CGC. Anybody else? Mr. N. Goswami, state respondent, and stop. Social justice, but he's not here. And Mr. So-and-so, learned counsel appearing for the social justice and empowerment, seeks how much time? 1 week time for filing return in the matter. What about others? You don't need to file. Then say, why are you waiting, Mr. Gogoi? Next, I don't believe in affidavits coming in piecemeal manner. Anyone wants to file, please tell me. Otherwise, your rights will be forfeited. And say list after how much? 2 weeks. List after 2 weeks to enable the enable all the respondents to file their return if they so desire. All right, August. Inform them.
Number 16.
Ms. Das. Yes.
I did it yesterday also. That has not been that one. People also would like to.
Then we'll call it on Monday.
Oh.
Monday. We will not direct, we will ask. Give a copy. Mr. M. Bhagavati, Learned Counsel, appearing for the petitioner, submits that an additional affidavit has been filed yesterday. However, the same is not on record. Let registry verify and place the same on record. List on such and such date. Monday, Parim? Monday or Wednesday? Wednesday? Wednesday. Give a copy.
Got it. I'm giving it now. Thank you.
Item 17.
Yes, needless to be clarified that since the issue involved in the arrangement pertains to non-release of contractual bill. Yes, Mr. Positive instructions.
Statement of the that is being considered at the highest level. And decision is going to be taken. So they have proper 6 week plan.
For what? 6 weeks for what?
Decide, because there are not many petition suppliers whose cases are being examined by the department.
Petitioner's dues are admitted or not?
They are under considered.
Then I can dispose it off by saying that you examine, and if the entitled, you make the payment. If the entire exercise has to be completed within 6 weeks.
But then there were out of the state, it's being filed.
Where?
There was an inquiry was conducted over it. Which inquiry was very clear.
No, but that is pertaining to those petitioners.
Yes.
So,
Statement.
no, those people are part of that inquiry, the petitioners, because show me your instruction.
Statement.
1 second. Yes, where is that? You have a copy of that affidavit in that case? No. Yes, well, I think I have extracted
Yes.
106.
Yeah.
So, in those suppliers, how do we know that you are also one?
Operative statement. But at the point.
1 second. Page?
31.
Yes.
Serial number 3.
Yes.
Durham. Present it. Serial number 14. The order with the annex file. The name of the petitioner are showing the government.
But it could be relatable to some other supply also. How can this be a concrete information? You see, because you have to appreciate that in your writ petition there is no affidavit. However, the instruction that has come is that some inquiry has been undertaken. Now, therefore, the only way, if you want a disposal, it could be that whatever inquiry they have undertaken, let that be completed, and after completing, if you're entitled, then it will be released, and the entire exercise can be finished within a particular duration. I think that's the only order which can be passed. We cannot direct them to release the fund to you. We don't know if you're entitled, not entitled. There is no affidavit. Very well, then you wait. You file an affidavit, and in your affidavit you clarify. Because you see, in that batch of writ petitioners, you have taken a stand that they are entitled after the inquiry, and accordingly, this court have passed the orders, right? So, if these cases are already covered, then there is no point of making further inquiries.
Yes.
Heard, Mr. R. Islam, Learned Counsel for the petitioner, also heard Mr. A. Bhattacharjee, Learned Standing Counsel, Revenue Department. Mr. Bhattacharjee has submitted that he has received instructions to the effect that against the matter of payment of outstanding dues to the petitioners against the supply of GR items during 2016-17 in South Salmara, Mankachar district, the same is under consideration at higher level, and a decision is yet to be taken in this regard. However, Mr. So-and-so Islam, R. Islam draws the notice of this court to the order dated 22/5/2024, where in similarly situated in the case of similarly situated suppliers, upon the stand of the state government that they are entitled to the payments made against the subject supply, this court has already disposed of the writ petition with the direction to the state government to release the outstanding dues of the petitioners in that writ proceeding. Okay, stuff. Mr. So-and-so, 6, how much time? Huh? 6 weeks? For what? No, you file your affidavit. You clarify this. Yes. 2 weeks time to clarify as whether the case of the petitioner is covered by the judgment and order of this court passed in WPC 3585/2019, along with the instructions, along with the up-to-date instructions as regards the case in hand. Give everything in 2 weeks.
Item 18 and 19.
Yes, Mr. Sharma.
No, your lordship. Okay. Because 18 might not, this, matter is before, 15 batch. That is, respondents will move the division bench against the rejection of the state application. The collective matter might not, 6142
Hmm.
can be heard by the,
No, in item, this is item 17, that's the first writ. Item 18 is the first one on board. In that, there is a division, there is an appeal pending. Appeal pending, and a stay has been also given.
take the fact that the particular contract was given to my American state. Catering contract, he negotiated guest house in one. Now, after operating for some time, on account of some dispute, he stopped operating the contract. Then he terminated the contract. Now, the termination was challenged in this WPC number 738 of 25. Now, the termination has been held to be met. But the only dispute which remained was beyond. In the meantime,
Termination was held to be bad by which court?
that is single judge.
Single judges. Already.
Yes. Now, my lord, here the claim of the petitioner is that he should be allowed to operate for the entire period of 2 years, despite the fact the period is also over.
In other words, the termination will not be given effect to.
Yes.
Hmm?
Now, my lord, consequently, the Damodar corporation's case, which court says, once the contract period is over, as far as operation part is concerned, that comes to an end. What survives, supposing if my defense success in this guilt petition, possibly he can file a civil suit where he can claim damages action. But under the law of contract law, he cannot claim to operate for the all period, so despite the fact that the period is over. Now, in the next case below, we have issued an NIT for the ensuing period. But there he has not participated. There is a stay by the honorable.
He has challenged the NIT.
But he has not participated in the NIT.
Then what is the locus, Mr. Sharma?
Exactly. You have to put this thing in a proper perspective.
I think this matter has to be heard properly. So shall I admit it?
So my submission is based on actually the matter was on last occasion, these two matters were deferred because the appeal is pending. On Monday, the appeal could not be taken up, it is fixed on 9.
Now the appeal is against the termination. Huh?
All against the stay order by which the NIT has been.
That is in 6142.
Yes. 7th period. I'm sorry, Billa. Oh, sorry, 24 PS 7.
So 6142 is disposed of, that means
No, this is alive.
it's still alive.
Being petition before the civil judge.
All right, we'll have it after in the next week, the next Friday. In the meantime, let's see what happens. Because Mr. Sharma, there is a connected matter and you are having a stay also. Yes. But I think at the end of the day, this matter is not such which perhaps can be disposed of at the admission stage. Pleadings are complete. It will require hearing. We may give you a short date, but it has to be.
Thanks, my lord. Witness, let us see how the
Okay.
appeal is.
All right, fine. Heard Mr. R. Sharma, Learned Senior Counsel, assisted by P. Fukan, Learned Counsel for the petitioners. Also petitioner. Also heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by B. Devi. R. Kakoti, Learned Counsel, appearing R. Kakoti, na? Learned Counsel appearing for the respondents. It is submitted at the bar that an appeal, a writ appeal in connection with WPC in connection with the stay granted by this court in WPC 6142 of 2024 is pending before the division bench, which is
Exactly. 78 that you have.
you're confusing me. The stay order is in WPC 738 of 2025 is pending before the division bench. which is which is fixed on the 9th, 9/6/2025. List this matters again on give Fridays, huh?
See that, another example, difficult, it is beyond 18.
All right, on 18 so and so.
Right.
18. Mr. Chaudhary, and Mr. Sharma, 18 may be a little difficult. I was just reminded. 18 and 19 you leave. 20 is it a holiday? It's a holiday, I think. No, 20 is open. All right, 20.
Item number 9.
Thank you, Rupa. Yes, Mr. Datta. Some affidavit, I think you are required to file. Item 12. Oh, SBI. Who is he? Because I actually wanted him. I'm sorry. Because I saw your name. Because I saw Shishir Datta and then I saw S. Datta SBI. So I assumed it is you. I'm sorry. But who is this S. Datta? Because apparently he was required to clarify. Anyway, we'll list it again next week. His name is shown in the cause list. S. Datta SBI Standing Counsel will yes and Nesoksan cause list. Item number kiman eto? Huh? 9. S Datta আছে কিন্তু standing counsel বুলি দিয়া নাই না ঠিক আছে heard Mr. S Sancheti RC Sancheti learned counsel for the petitioner also heard Mr. Shishir Datta learned senior counsel assisted by MSS Muchari learned counsel for the respondent number 5 Nabard. None appears for respondent number 7 SBI. It appears that the respondent SBI was required to submit clarification for which the matter was posted today. In view of no appearance on behalf of the respondent SBI, relist the matter on next Friday, dated on such and such date, by reflecting Mr. S. Datta, Standing Counsel SBI, the name of so-and-so, in the cause list. Info. Diok file to Diok. Asile ji code gusi gol. Ta file to Diok mo. কি আছিল এইটো কিয় থোৱা হৈছিলে কেছটো দিলে What do you want to show from this case now, Mr. Goswami? He can MA City Court. Matak could go. The none appears for the petitioner on call, released next week on any date to be fixed by the registry.
Number 20.
You have not received?
Because there is a earlier company today. You are allowed there.
So you give him a copy. He has not received. Give him a copy. This is item 20. All right. Mr. S.D. Purkasta, Learned Counsel, appearing for the respondent number 1, submits that he has not received a copy of the second appeal. Mr. S. Nath, Learned Counsel for the appellant, assures that a copy of the appeal memo, second appeal memo, shall be furnished to the Learned Counsel appearing for the respondent by the course of the within the course of the day. Released after a week on a date to be fixed by the registry.
21.
Yes, draft. Where? I can't find. Wait. Yes.
Whether it's standard for successful in deciding that the finally part and
Deciding the issue number C, which is neither framed by the learned trial court nor during the appeal. So an issue was decided which was not framed. What is the facts?
particular strike that an interest will as well as the election of the defendant. The defendant is he has to fight the legal statement along with the account. The learned trial court has dismissed the suit and decreed the counterclaim by saying that this is entitled to retain the possession of the suit.
You have filed a counterclaim. And your counterclaim was rejected on what ground?
Allowed my counterclaim only with regard to that the defendant retains the possession of the suit. Against that one, the plaintiff filed an appeal.
First appeal. And the first appellate court?
The appellate court has declared the right and the plaintiff. And also the decision of
What was the reason of the appellate court in reversing the finding of the trial court?
the plaintiff says that my lord is 10,000 from the defense end, and he has handed over the possession of the state to the defendant number 1. On the condition that whenever he will return the money, the defendant number 1 will return the suit. So he has filed the suit for the recovery of the person as well as the
What is wrong in the order of the appellate court?
part in the settlement. Another, we got to see the council claim. The council will be back by limitation of the ground that says the thing for suit can be filed.
What is the substantial question here? It can be a question of law. The question has to be of substance. What is substantial? Any question of law is not substantial question of law. It has to be a question which has some substance, which is not decided earlier. Isn't it? Is there a bar? No, CPC console? But this was by the appellate court. One second. Because ultimately, it's a procedural. Now, if the first appellate court has not followed that procedure, on that ground alone is the appeal bad, the order of the appellate court bad. Yes, which order? (23). No, that is familiar issues by the trial court. I'm talking about the appellate courts. You'll examine properly, relists on any date next week. Look into that part, that order 43 something it is there, because what is the contents of the appellate court's order, whether non-framing of the issue can be a ground. Check that. Next.
For order item number 22.
Yes, Ms. Decca. What about the impleading? When? Huh? All right, Mr. Ashok, learned counsel appearing for the petitioner seeks 2 weeks time to file the necessary impleading application in the matter. Prayer is allowed, relist after 2 weeks and a date to be fixed by the registry. You do what is to be done. I'm not recording. This is for dismissal. All right. All right. This matter has been fixed today under the order column with the remark for dismissal in view of non-appearance of on behalf of the petitioner on the last occasion, i. 2/6/2025. However, when the matter was called today, with the aforesaid remark, Mr. A.K. Talukdar, learned counsel, has entered appearance on behalf of the petitioner. Mr. N. Goswami, learned counsel for the state respondent, is also present. Yes, this matter has to be now for admission. What about the affidavits and all? Huh? Huh? On the last occasion, this matter was listed under what column? admission, list for admission after a week on a date to be fixed by the registry.
24.
Yes, this RSA has so nothing is to be done. MS, your name? MS B. Chaudhary, Learned Counsel, appearing on behalf of Mr. DM Nath, Learned Counsel for the appellants, submit that upon upon verification, it is learned that the legal heirs of the deceased respondent number 6 is already arrayed as respondents 1, 2, and 3 in the present appeal. It appears that the case records, it appears that in view of the aforesaid submission, no substitution application is required in respect of deceased respondent number 6. Stop. It further appears that service but the service says 4 is served. I can only see is number 4. What about the others? $21. Yes, I have 21,525. It talks about only R4. What about the others? Huh? Miss Counsel, you're not following. Yes. It further appears that service in respect of respondent number 4, as per office note dated 21/5/2025, is completed. It further appears that as regards respondent number 1, 2, 2 to 5, 6, and 7, by office note dated 5/3/2022, service stands completed. No, sorry, don't say like that. It further appears from the office note dated 5/3/2022 that notice issued by usual process in respect of respondent numbers 1 to 7, the same has been duly served upon respondent number 1, and in respect of respondent number 2, 3, and 5, the elder brother has accepted the notice. And 7, huh? And 7, the elder brother has accepted the notice. It further appears that respondent number 6 has expired. That being so, the service stands complete. List for Hearing now, I think it can be um, list for hearing in the usual course.
26.
All right. Heard Mr. T, na? D. Chakraborty, learned counsel for the petitioner. Also heard Mr. D. Das, learned counsel, appearing for the respondent number 2. Mr. Das submits that the affidavit in that the affidavit in opposition shall be filed within the course of the day. In view of the aforesaid assurance, relist the matter after 2 weeks on a date to be fixed by the registry.
28.
Yes. Infractious. Heard MS J. Ghosh, learned counsel for the petitioner. Anyone for the contemptors? No. MS so and so, learned counsel for the petitioner, submits that in the meantime, why has it become infra complied? In the meantime, since the judgment and order dated 1/9/2022 passed in WPC number 2209/2014 has been complied with, the instant contempt petition has become infractious. In view of the aforesaid endorsement, nothing survives for adjudication in the instant contempt petition. Accordingly, the contempt petition stands closed.
29.
Yes, Ms. Som. Affidavits filed? Yes. Page. You are the sole respondent. Page. Yes. This is a division bench order. No, but you have filed against this order, the contempt. Is this not a division bench order?
Single bench lordship. Lordship again, page 30. Referring to the
Oh, page 31.
bench order.
Page 31.
Page 30. Right again. The order dated page 6, 2022.
29 and 30.
29 and? Yes, 29.
Yes.
Chief Justice, and 30 is Honorable Justice Soumitra Soikia, and then division bench, and in 31 the signatures. Yes, it's a division bench. So I don't understand what is the confusion. Huh? Why is this matter filed here then? And you had filed your affidavits. You didn't notice. No, whatever be it, how can this contempt petition lie before the single bench? It's the case is in fact the order is passed in a PIL. But I think it was taken up together. Miss Rome.
I'm referring page 28.
Correct, Miss Som, but it's a linked case. This is taken up by the division bench. What is so difficult to understand? What is so difficult to understand? How can this be? Isn't it? I am not concerned with your core issue, Miss Som. How do you expect this single bench to now look into the non-compliance of a division bench order? Which would be the appropriate bench for this contempt petition? I think perhaps the registry can verify, isn't it? Huh? It appears that in the contempt case, in the instant contempt case, the judgment and order of the division bench dated 8/6/2022 is alleged. You see, Miss Counsel, the difficulty is when you had given in, you have not mentioned the entire, you have to give all of them because this was a common order. So, to me, main first to in PIL 27/2013, along with WPC 482/2021. Let registry verify and place the matter before the appropriate bench. RSA. Case records have come. Case records has come. Now, what about 8 to 11? Where is the petition? Where is the appellant counsel? You are for the respondent. None appears for the appellant. Mr. Your name? A.K. Hanan, learned counsel appearing on behalf of the respondent is present. Lists after 2 weeks on a date to be fixed by the registry. Mr. Counsel, the appellant is not here. You are the respondent. Yes. Yes.
31 was expired. Earlier it was
31 was expired. You mean 31 expired means what? The appellant number 31. The respondent number 31. Huh? Mr. Counsel, you are saying 31 expired. Respondent number 31. I don't find any 31 respondent here. Huh? Mr. Counsel, be sure of what you are speaking. Please be mindful. Yes.
2024. After extract of some of the respondents.
Yes.
Therefore, as per order dated so it one A.
Please don't refer to the name of the judges. This court. Yes. Once you say 15, then you say 31, then you say 15. All right. So Fakrun Nessa died. And then you filed that you've done. You have to, so you want what to do? Say that, just say that, Mr. Your name, A.K. Anand, learned counsel appearing for the appellant, submits that 2 weeks time be allowed to do the needful in order to file the necessary substitution to 6 time to do the needful to file the necessary substitution application in against in respect of respondent number 15 stop in accordance with law. List after 2 weeks on a date to be fixed by the registry. All right, Miss MS so R1 to 14.
I'm happy to.
What is this miss case? Restoration. Mr. So and so, learned counsel appearing for the applicant seeks accommodation for taking fresh steps in respect of respondent number 2, right? 2. In 2. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry.
Happy to.
Who is appearing? Last time also there was no representation. But I think they have not taken steps.
Yes, sir. Upon respond number 5 and 6, you know.
None appears for the petitioner on call. MS
Ardeka.
Ardeka, learned counsel
for appearing for respond
is
number
present for respondent number 1 and 4.
1 and 3. Yes, your lordship.
Huh?
1, 3 and 4.
1, 3 and 4. It appears that though on 9/9/2024, this court had directed the learned counsel appearing for the petitioner to take fresh steps for service of notice upon the respondent numbers 5 and 6 by registered post with AD. However, the office note dated 31/5/2025 indicates that steps has not yet been taken. Be that as it may, in the interest of justice, list this matter after 2 weeks on a date to be fixed by the registry. In the meantime, let registry intimate the order of this court and the next date of listing to the learned counsel appearing for the petitioner. Fix or at a date deliver. 2 weeks after the deliver.
Please, Your Lordship. This is a contempt petition alleging violation of the non-compliance of the order dated 2012-2022. Passed in the petition.
Mr. Vishwakarma,
Yes,
affidavits have been filed or not?
Affidavit is filed.
Affidavit in files. Yes, which is the order? Page?
Page 15. It starts at page 15. The relevant part is at page 23 minutes.
Yes.
May I read it? Milord?
Yes, please.
In view of the aforesaid facts and
Take
circumstances.
another tea.
Why?
Mr. Esbora is on legs.
Huh?
Mr. Esbora, who is appearing, he is on legs.
Yes, read.
In view of the aforesaid facts and circumstances, both these writ petitions are disposed of by directing the GMC and GDD to undertake a verification exercise which would include the measurements of the works done. It is needless to mention that such measurements have to be done in presence of the representative of the petitioner so that no prejudice is caused to either of the parties. It is clarified that the measurements have to be done independently for the individual works. The aforesaid exercise to be completed within a period of 2 months from the date of receipt of the certified copy. After such verification, the payments be made expeditiously as indicated above, and no forfeiture clause should be invoked, as the challenge to the termination of the termination itself is not pursued in these writ petitions. This, however, will not be a precedent for other works. So what had happened was in these writ petitions, there was
Slowly, Mr. Vishwakarma.
what had happened was there was a tender was issued by GMC for cleaning and of the drains, cleaning and siltation of the drains within the body. So there were 71 packages. There are 18 petitioners right now. So they were awarded works. So they had undertaken the works were the work orders were issued on 11/5/2021. So the work was for 12 months. So the work was divided into two parts. The cleaning part was there and maintenance part was there. The cleaning part was to be completed within 3 months. Merely not 1 month had gone after the issuance of the work orders. On 8/6/2021, after almost 27 days, a show cause notice was issued to each of the petitioners, alleging that as per the particular report of the divisional engineer, the petitioners had completed only 25 to 30% of the works. And so they had not been able to proceed as per the milestones, had not been able to achieve the milestones. And so the show cause was asked to show to us as to why our agreements would not be terminated. So we had replied to that. We said that within 1 month, we have been able to achieve 25-30%. So that's more than what was needed. So in spite thereof, our works were terminated on 12/6/2021. We immediately approached this honorable court. We had filed a writ petition saying that challenging our termination as well as for payments. So in the course of the writ petition, while disposing of the writ, we gave up the prayer for termination of the writ petitions. We said that at least pay us what we are due. So that's how, alleging non-compliance of this, we are here. They have filed an affidavit, my lords. We'll take up the affidavit.
Page.
It starts as page 29. In the affidavit, basically the GMC is saying right now that since the work was of 2020-21.
What is the affidavit?
Starts from page 29, running page.
Yes. Yes.
In the affidavit, the GMC is saying now that since the work was of 2021, so naturally physical measurement is not possible right now. So we agree to that. But even if physical measurement is not possible, but there ought to be some measurement books were maintained at the time of when the work was undertaken by the engineers. So pay us according to that. And in fact, while show cause notice was issued to us at that relevant point of time, in the show cause notice, there was a mention of a report of a divisional.
But in that situation, Mr. Vishwakarma,
Yes.
because in order for this court to hold the contemptor guilty, what is required to be established
Yes.
is willful and deliberate
Yes.
disobedience.
Yes.
Right. Now, suppose it is not possible, then perhaps you may have to go for a review of that order, or I don't know. But,
May I point out one more document from the affidavit?
because you see, this is not an executing court,
Yes, I understand that.
correct?
Yes.
So if you can show that there has been a willful disobedience, it is another thing. But if suppose what you just said,
Yes.
that according to them, it is difficult for the measurement.
A physical
Now-
measurement may not be possible.
Correct, but so whether is
Yes, I understand, Malus.
the obedience, mere
Yes.
obedience is not contempt.
Yes.
Mere disobedience is not contempt. It has to be
No, willful and
willful and deliberate, right?
Yes.
You look into it. Mr. Bora is not here today.
May I point out one more? Malus will take up page 44 of that affidavit. Malus.
Page 44.
44.
Yes.
Plus, what had happened? There were altogether 71 packages. So we were not the only ones who had filed the writ petition before this honorable court. There were several writ petitions filed. So in other writ petitions as well, there were orders passed. to
Those were
make
complied.
payments. They have been complied with. So in fact, along with our writ petition, there was another writ petition.
All right. Next speaker, Kundina Divaparetu. Ask Mr. Bora to be here on the next date. 13th? Relist on 13th. Mr. Gigi for appearance. Heard Mr. S. Biswakarma, Learned Counsel appearing for the petitioner. Also heard MS.
J. Rajkumar.
J. Rajkumar, Learned Counsel appearing for the respondent contemptor. She MS so-and-so seeks a short submits that Mr. S. Bora, who is the arguing counsel on behalf of the respondent, due to is on legs, no? You said is on legs before a coordinate bench of this court, and accordingly seeks a short accommodation. Prayer is allowed. Release not sufficient.
May it please your lordship.
Yes.
Lordship state has been completed against all the respondent lordship.
Huh?
The latter matter may be list on admission for hearing. Lordship.
What did you submit? Sorry. Steps complete.
Yes, lordship.
Respondents all have appeared.
I am for respondent 7, Lordship.
What about the other respondents? Not appeared. Mr. Upamanyu had appeared on behalf of 8 to 11, Mr. Borua 12 to 14, Mr. NJ Gogoi 7. I can't see much of the councils today. Yes.
Yes, Lordship, I am appearing for 8 to 11.
8 to 11. Where are the others?
13 is the commission.
Returns. What about returns?
I got 12, 13.
Yes. Are you all not filing any return?
The main grievance is against that SBI life insurance, Lordship.
No, but returns, are you filing or not filing? Otherwise, I'm fixing it for here admission.
Lordship, in this year, respondents have, we don't want to file any affidavit.
Heard MS?
J. Biswara.
J. Beshborwal, Learned Counsel appearing for the petitioner. Also heard Mr. NJ Gogoi, Learned Counsel appearing for respondent number 7. Mr. D.
Yes, Lordship.
Upamanyu,
Yes, Lordship.
Learned Counsel appearing for respondent numbers 8 to 11. And Mr. N. Goswami,
12.
Learned Counsel appearing for respondent numbers 12 to 14. What about 1 to 6?
They are the main parties.
Now, what happened to their 1 to 6? Office note in respect of respondent numbers 1 to 6, office note dated 25/2025 indicates that notice to respondent numbers 1 and 2 was duly delivered on 3/3/2025. And notice to respondent number 3 was duly delivered on 5/3/2025. Office note dated 25/2025 indicates that notices in respect of the said respondents have been delivered to the addresses on the date mentioned below. A to A office note to Friday. Yeah, Friday. Further, it appears that a communication has also been received from the respondent number 6 on 24/2/2025, wherein it has been stated that a copy of the notice has been duly received by the said respondent. That being so, the service in respect of respondent numbers 1, 2, 3, 4, 5, and 6 stands complete. List for admission. In the after 2 weeks, I need to fix them. Yes.
Lordship, here I'm appearing for respondent.
Yes, Mr. Chalia.
Lordship, here instructions are still awaited, Lordship. Here.
Regarding
24, contempt.
Lordship, yes, Lordship, we have informed the department. Lordship, I only.
Why? So
No,
much
Lordship.
time in contempt cases?
Yes, Lordship, I apologize, Lordship. 2 weeks time may be granted, Lordship.
Department doesn't seem to care for contempt cases anymore, Mr. Chalia.
Lordship,
It is
Lordship, I will.
dangerous for the institution.
Yes.
The
Lordship.
institution will collapse if this is the situation
Lordship will.
where departments are not even bothered after receiving show cause notice to show the minimum courtesy of responding.
Lordship, I apologize, Lordship. Lordship will grant me 2 weeks time, we'll press on it, Lordship.
Heard Mr. P. Sharma, learned counsel for the petitioner. Also heard Mr. A. Chalia, learned counsel appearing for the
Respondent 1 and 2.
respondent number 1 and 2 contemner. Contemners, huh? Respondent stroke contemner number 1 and 2 go back. Mr. A. Chalia, learned counsel for the petitioner. Seeks
For the respondent, respondent.
Huh?
So H earlier for respondents, Lordship. Lordship.
respondents.
Yes, Lordship.
There are 2 respondents only.
Yes, 1 and 2, Lordship, please.
Only 2.
Lordship had said, Mr. H earlier for the petitioner, Lordship had said.
Petitioner question again.
Also, there are 4 respondents.
I'm for 1 and
Contemners
2.
stroke respondents. Number 2, 1 and 2. So Mrs. Chalia and it's so and so for respondent 1 and 2. 1 and 2, na?
Yes, Lordship.
Seeks
2 weeks.
2 weeks time to file the necessary affidavit in opposition in the matter. Say he assures.
Lordship.
So and so assures that the affidavit in opposition on behalf of the aforesaid contemners shall be filed positively within.
Within, Lordship, 2 weeks. Last,
Yeah.
Lordship.
Yeah.
Or at least we'll place the compliance report. Lordship.
No. Mr. Chalia,
Yes.
I do not want any compliance report to be passed through. You see, this is a court and a contempt court.
Yes,
You file it.
yes, Lordship. Lordship.
You file it.
Lordship.
Right? In the papers will not be taken across.
Lordship. Lordship.
This is not. Is it permissible under any of the guidelines, High Court rules?
Lordship, yes. Lordship will.
What is it, huh?
We'll file the affidavit, Lordship.
The contemptor has got a show cause notice from
Yes.
this. What does the format says?
Lordship, we'll have to file.
What does it says?
Yes, sir, Lord, we'll file a affidavit, Lordship.
So you file your affidavit.
Lordship.
If you have complied, you file your affidavit showing your compliance.
Lordship.
Positively file the affidavit in opposition within
Lordship, the last week of June, Lordship.
last week of June. Will be within 3 weeks or 2 weeks?
3 weeks.
Within 3 weeks from today. In view of the aforesaid assurance, relist after 3 weeks on a date to be fixed by the registry. It is needless to be clarified that since this contempt petition has been pending since 2024, in the event the 2024 and the contemners has received the notices on 2/12/2024 and 3/12/2024 respectively, comma. কেলেকে আরম্ভ করেছিল তাৰপিছত And then since the contemners, since the aforesaid contemners have received the notice on 2/12/24 and 3/12/24 respectively, the affidavit in opposition, if is not filed by the next date of listing, necessary orders as required for securing their appearance shall be filed, shall be issued.
Like.
Yes, yes, what is the confusion of who wants to have the audience? Huh?
I filed my Ukalatama, but my junior's name is shown, but my name is not shown.
Acha.
In this case, Lordship, we want to file our.
Your junior didn't tell you.
Lordship,
Your junior didn't tell you.
Lordship.
You want to file what? Objection
Objection,
to 139 days delay.
Lordship. There are
Serious objection you have.
Lordship, objection in that sense, Lordship, there is no proper explanation in the
Let us see
Petition.
what is the explanation.
Lordship.
Yes, Mr.
I'm
And
going for another date, my lord. This brief, my lord, I was not prepared with.
Ajay, as prayed for by Mr. K. Majumdar, na?
K. Majumdar,
K.M. Majumdar, Learned Counsel appearing for respondent number
1 and 2.
1 and 2.
Both of us here,
She also wants.
Lordship.
She is for?
Respondent number 1 and 2.
1 and
You
2.
both are appearing for 1 and 2.
Lordship. I filed my Wakalatama subsequently. No
Uh,
problem, Lordship, we want to file our objection.
please sort it out.
Sorry.
Who is appearing before this
Lordship,
court
no
for 1
problem,
and 2? This court is not going to be now hearing two counsels for the same set of.
Lordship, my name may be shown, Lordship.
You sort it out. These things should not come before this court. If there is already an existing counsel,
Lordship.
before the second set of counsel represents that party, there should have been an NOC obtained from the earlier set of counsels. You please follow it up, what is to be
Lordship.
done and not done. Otherwise, this court is going to take serious note of all such
Lordship.
things. So and so seeks 2 weeks time to file objection in the interlocutory application. Prayer is allowed to relist after 2 weeks on a date to be fixed by the registry. I am not noting today,
Lordship,
but
Lordship, that may not be Lordship.
you
We are-
check it out.
Lordship.
Public.
Yes, Mr. Jha,
Please, your lordship.
658 days delay.
Yes, yes.
For what?
Your lordship, because of my illness,
For filing the second appeal.
no, not second appeal, your honor. Your lordship, in the meantime, your lordship, the defendant number, respondent number, your lordship died, 2C. Jyotish Sarkar died.
Abatement and substitution.
Abatement, substitution and limitation, lordship, all the things.
Huh? Abatement, substitution
And limitation, your lordship.
so condonation to is in front of me, I know.
Your lordship,
So abatement and substitution.
your lordship.
What is the ground of delay? Yes, ma'am. You have any objection?
Yes,
You have. You want to file
yes.
as prayed for by MS,
As Paul,
as Paul and counsel appearing for the respondent number
7, 8, 9, 10, 11, 12, 13, 14, 15, 17, 19, and 20.
Pala. Relist after 1 week on a date to be fixed by the registry to enable the said respondent file objection to the condonation application.
Much obliged.
It's a criminal miscase.
My lord, we are extremely sorry, my lord.
Yes, Mr. Goel.
Your lordship's order is at page 13.
Mr. For rate RSA and now criminal. It takes time,
Yeah.
you know, to reconnect.
Yes, ma'am. Even we are not used to it, my lord. But
Ye-
now we have to adapt to different
Yes, of course,
circumstances.
of course.
My lord.
Yes,
My lord, what has happened, it's very unfortunate, my lord, that my junior counsel's names were shown in the cause list. They normally do the charge on my name. That's why it has happened in my case. I have also appeared in the, for,
no, what happened?
well, it was dismissed for default because my
Where is the order?
page 13 in the IA. In the,
Alright.
in the criminal
Uh,
miscase number 1 of.
All right, a criminal miscase. This criminal miscellaneous application has been filed for restoring the what is the for restoring the
Criminal
criminal
petition
petition 380 of 2016 to its original file, which was dismissed for non-prosecution by order dated 26/3/2025. Stop. The grounds avert in the restoration application is sufficient and bona fide. Accordingly, the restoration is allowed. The the order dated 26/3/2025 passed by this court in criminal petition number 380/2016 is accordingly set aside and recalled. The criminal petition be restored to its original record, it says, na?
Yes, ma'am.
Restored to its original record. Allowed. On top, you say, heard Mr. B.D. Kaur, learned senior counsel assisted by counsel.
We have also filed, normally when it is restored, the interim order is also restored, but we have filed a separate application for restoration of the interim order. That is IA number
This is
402.
disposed of, huh?
Normally, we are not required, but I have taken as an abundant caution and filed this IA 402 of 2025.
Only thing, last time there was this council, the Bora. So in the interim, perhaps I'll have to issue a notice.
Well, till the next date, because once it is restored, the interim order is restored. But
If that is the interpretation, it will be automatically done.
But yeah, I think they
But
try
you
for,
see, Mr. For to
then
dispose of your that IA would be difficult today.
no, your lordship will just in the interim for a limited
I
duration
prefer-
402. Because what has happened, my lord, in this case, there was an arbitration award in our favor. It is in respect of a vehicle. And that by suppressing all these things, my lord, he has filed a complaint. That's why the court at the initial stage only has passed this interim order. My lord. And the man is now 62 years based in Calcutta, and he has recently undergone a surgery of the
Had
stroke.
Mr. So-and-so, learned counsel so-and-so, issue notice, issue, I think you can serve the other, the council or
The notice has to go because they will not
issue
accept.
notice, returnable, and state sir, Mr. State any PPs, yeah.
No, but it's a complaint case.
Is at liberty to serve the notice in respect of the state respondent to the before the through the office of the PP. And in the interim,
Your lordship's earlier order is at page 15, my lord, of this IA.
in the interim, which is that order which where there was a stay already operating
Page 15 of that IA.
in the interim.
Last line at page
The-
16.
The proceeding of the
TR case number 131.
PR case number 3130/2014 stayed by the order of this court by order dated 23/5/2016 if was continuing till the date till 23/5/2016 on the date on which the criminal petition was dismissed for non-prosecution shall continue till the next date of listing.
Well, it was there on page
Is
16.
that right?
Yeah. It just said that till then the proceeding of the
You see,
Yes, yes.
it makes
We are obliged. Yeah.
just your purpose is served and I am
Yes, yes.
protected, Mr. Kaur.
Yes, we are obliged, man. It normally doesn't happen after a long, many years.
It's all right, Mr. Kaur.
Yeah, sorry.
In fact, I realized later perhaps it's a criminal petition. I should have appointed someone.
Amicus curiae. I am not taking that ground, but normally criminal revision appeal, your lordship appoints an amicus curiae.
Yes. No
We
problem.
are blessed.
May I please? Lord?
Yes, Mr.
Lordship, I take
Decca.
41 and 42 both. Similar.
We are appearing, for the respondent contempt.
Are you intending to file something?
Yes, Lordship.
That's why
That will
when?
be given.
Huh?
I'll just point out, Lordship, page 13.
What is there to point today,
No,
Mr. Decca?
no.
Let them file their.
They have admitted the amount to be paid.
There is
in the
a admission, my
repetition.
lord, you want to show, my lord.
They have admitted to be paying it. They have not paid last one.
Why you're not?
So
In
what-
repetition, they have admitted. The
Six
order
time will be
was
given for filing affidavit.
Huh?
6 time will be given for
You
filing.
know what? 3 weeks? 1 week? You sure?
Last time, Lordship.
Maybe.
My lordship.
But why are you not complying with the court's order
they have
when
admitted.
you have already admitted?
Lordship. Take instruction, Lordship.
Huh? Is that some kind of a joke that you will not respect the orders of the court? So you find whatever you have to find.
And Lordship,
Heard Mr. D. Decca. D, right? Learned counsel appearing for the petitioner. Also heard Mr.
D Google.
D. Gogoi, learned counsel appearing for
One and two.
Respondent number 1 and 2, only 2 respondents.
Yes, Lordship.
Mr. D. Dekar, learned counsel, so and so seeks for 2 weeks, takes 2 weeks time to file show cause, to file show cause reply in the contempt petition. Prayer is allowed. It is needless to be clarified since the admitted, since the
Page
dues,
13.
dues of the petitioner is an admitted amount which was directed to be paid by the order dated 27/5/2024 passed by this court in WPC number 5194/2023. The show cause reply shall be positively filed by the next date of listing, failing which necessary orders as required shall be issued. Relist after 2 weeks on a date to be fixed by the registry.
Lordship, both
42 is similar.
42 is
Which
Only
one?
the repetition number would be different.
Which one? Which one?
42, next item.
40. Give me the repetition number.
That would be, Lordship, 5261 of 2023. Date is same.
Wala. You filed it, it's an admitted amount.
Lordship.
What is there to explain now? You have any grievance, you could have gone for an appeal. Yes.
Blind Lordship.
Willful violation of this honorable court's order dated 31/5/2024.
Yes,
In
Mr.
fact,
Abar Pujari, what is your affidavit?
I am representing R1. So we have received the notice issued by this honorable court, but we have only received a copy of the contempt petition without the annexures, number 1. Number 2, my lord, we have filed our power. In the website, my lord, it is shown, my lord, our names are shown that we have filed a wakalat number. The wakalat number I do not find in the record.
That is all right.
Yes.
You want to
Nonetheless,
file,
I will file an
you
affidavit.
file your affidavit. In the meantime, you
No,
give
that
him a
is fine.
complete set of
Complete
petition.
So they will kindly accommodate me
this
for 4
order
weeks,
has
my
been passed with the consensus of the
All
respondent.
right.
Definitely.
Heard
Will be
Mr.
R. Islam.
R. Islam, learned counsel for the petitioner. Also heard Mr. R. Borpujari, learned counsel appearing for contemptor
1.
number 1. And Mr.
Respondent number 2 on behalf.
Your name?
R. San.
R.
R. San.
Sahini.
Yes.
Learned counsel appearing for on behalf of
Tina.
Mr. D. Nath, learned counsel appearing for contemptor number 2. Two. Only 2 contemptors?
Yes.
Two.
The learned counsel appearing for the contemptor seeks 2 weeks time.
They will kindly accommodate me, my lord, for 3 weeks, my lord.
3 weeks time to file return in the matter. Prayer is allowed. Relist after 3 weeks on a date to be fixed by the registry. I am not saying about the.
Yes,
yes,
incomplete
I'll-
delivery.
I will seek a
I'll
copy
give
from
my-
him.
I'll give. Much
So obliged.
40.
My lord, as per the office note, my lord, the service upon all the respondents are complete.
Yes,
As
Mr.
per,
Kaur.
as per the office note dated, as per the Lauzima order dated 16/5/25. So now the matter may come up for admission, my lord.
All complete.
Yes, my 7 has, notice has been served upon respondent 7. 1, 2, 3 is the fishery department,
You are for 1, 2, 3.
Yes, sir. On behalf of P. Sharma.
and 4, 5, 6 is the government of Assam circle officer, then district commissioner.
4, 5, 6.
456 I am appearing.
So that's all.
Yes, my lord. 7 the service is complete.
Heard Mr. S. Khaun, na?
Yes, ma'am.
S. Khaun, learned counsel for the petitioner. Also heard Mr. K. Deb.
KD Sharma.
Huh?
KD Sharma.
K.
D Sharma.
D. Sharma. Kapil Dev Sharma.
Yes.
K.D. Sharma, learned counsel appearing for the respondent number
1, 2, 3.
1, 2, 3, and Mr. A. Bhattacharjee.
SR Burwa.
Huh?
SR Burwa.
S.R. Burwa, learned counsel appearing for respondent number 4, 5, 6.
6.
Stop. Office note dated 16/5/2025 indicates that service in respect of respondent number 7 has been completed. However, there was no representation on behalf of respondent number 7 when the matter was called today. In view of the fact that service has been completed on behalf of all the respondents, list this matter for admission
Yes, ma'am.
after 2 weeks on a date to be fixed by the registry. None appears for the petitioner on call, relist after 4 weeks on a date to be fixed by the registry. None appears for the petitioner on call, relist after 4 weeks on a date to be fixed by the registry.
Malad, in 47, I'm appearing Malad for the respondent matter.
And I said 47, Mr. Hardhar, learned counsel for respondent,
1 to 4.
1 to 4 is present.
My lordship, I'm sorry, my lord. On last 2 occasions, I not appeared.
All right.
And
Um,
today, my lord, tried.
This matter has been listed today with the remark for dismissal in the order column in view of the fact that on the last occasion, I-4/6/2025, there was no representation on behalf of the petitioner on call. Today, when the matter has been called, Mr. K. Bhuya, learned counsel appears for the, is present for the petitioner. Mr. A. Bhattacharjee, standing counsel revenue is also present. List for now, it is supposed to be.
The respondent number 7 already filed affidavit, but other has yet not filed any affidavit.
This matter can come for admission. All the respondents are represented. List for admission
For admission.
in the usual course.
Matter, my lord, the very issue is very simple.
All right, next.
Obliged, lordship.
Oh. None appears for the petitioner on call. It appears that this petition was listed today under the order column with the remark for dismissal in view of the fact that there was no representation on behalf of the petitioner, despite the matter being called twice on the last occasion, on the last date of listing, I-4/6/2025. Mr. A. Bhattacharjee, learned standing counsel, revenue and disaster management is present in view of the non-consecutive, in view of the non-appearance of the learned counsel appearing for the petitioner on the last, consecutively for the last 2 occasions. The writ petition stands dismissed for non-prosecution. None appears for the petitioner on call. This matter has been listed today with in the order column with the remark for dismissal. In view of the fact that on the last occasion, I-4/6/2025, despite the matter being called twice, there was no representation on behalf of the petitioner. Today, anybody appearing? Mr. Roy, Government Counsel, Revenue, MSN Borderloy, learned counsel is present for standing counsel, learned standing counsel, revenue and disaster management is present. Anybody else? Government counsel? All right. Absolutely dismissed for non-prosecution.
Lordship, I pray for reflecting the name of SC Revenue. Lordship.
I've dismissed it.
I'm sorry.
Ms. Borderloy?
Sorry about it. And for respondent.
Yes, I've dismissed it. I've recorded your presence. You want your name to be shown in the cause list? No. Yes, Mr. Nayak, that matter is 54.
Yes, item number 54.
The affidavit has been filed.
If it has already filed, now it is in record.
Yes, I think a request has come.
Yes, Principal Secretary BTC is online.
So do you want me to take it right now or at 2?
As your lordship with Lord.
No, if the principal secretary do.
He's online?
Otherwise at 2 also if it is
possible. At 2.
At 2?
At 2. Maybe 2000 minutes.
Affidavit for Lisa. Affidavit has not come. Mr. Nayak, you have a copy of the affidavit.
Yes, Lordship. Copy to be
You have received.
I don't. Extra copy there.
All right, then you. Which one is which page? Non-compliance?
Lordship, in my affidavit,
1 second. The order is this.
operative portion has been quoted, Lordship. In page 31.
Page?
Page 31, paragraph 3. Lordship, may kindly come to the quoted portion, Lordship. 7. Having considered the content. Is Lordship there? Yes. Having considered the contents of the said order dated 15/11/2021 and the decision of the full bench judgment of this court rendered on 29/9/2008 in writ appeal number so and so, Tamsir and similar other 194 petitions reported in 2008 4 GLT 1FB, it is considered appropriate that the respondent authorities in the respondent BTC shall undertake and complete similar kind of exercise like the one mentioned in the order dated 15/11/2021 in respect of the claim of the petitioner, also within a period of 3 months. If after such exercise, the petitioner is found entitled to the amount of rupees 18,80,069 as claimed herein.
Entitled or not entitled?
He has been found entitled, Lordship.
Found entitled?
Yes.
So then why is he not being paid?
No, that is the issue, Lordship. As per Tamsir Ali, Lordship, first we prepare a list, Lordship, consolidated list, and then we start paying chronologically, Lordship. His position is at 100, Lordship. If Lordship comes to page 40. Page 40, 99 and 100, both the contender, the petitioner, Lordship.
Page 40.
40, it's a table, Lordship.
Yes, where you have marked.
99 and 100, we are concerned with 100, Lordship. 18,80,069, Omar Ali Sheikh, Lordship.
We are concerned with 100.
Yes, Lordship. So this was direction, Lordship. First, prepare a consolidated list and then pay in.
Where do I get Tamsir Ali, that part of the direction?
Tamsir Ali doesn't.
You have received a copy.
Yes, find out.
I think now nothing is to be done then.
Let's see, they have admitted the amount, but yet not they have released.
Yes, because it will be paid in terms of the direction contained in Tamsir Ali.
My submission is at 33, Lordship, page 33.
You see, Mr. Counsel, when you file a contempt petition, a mere disobedience is not contempt. It is disobedience is if it is willful or deliberate, only then. Now here it appears that they have done the inquiry, but how much time? When
Lordship,
was this
Lordship,
inquiry
kindly
done?
come to page 33, Lordship.
Page
33, 33.
Yes.
Accordingly, it is most humbly submitted that the due amount of the petitioner will be released as per the aforementioned list in a chronological order in terms of the judgment passed in the Tamsir Ali case. Lordship, at the moment 39, serial number 99 is paid, next will be his number, Lordship.
Nothing is there then. They're satisfied. But Mr. Nayak, you see, if this affidavit would have come on the day one, it saves the embarrassment of the contender to connect with the court.
Yes, Lordship.
In the video conferencing.
Yes, Lordship.
Why the affidavits are not filed? You must sensitize your departments.
Yes, Lordship. In fact,
even today in many matters, they were insisting of giving a compliance. See, compliance cannot be just passed.
Yes, Lordship. Yes.
These are contempt proceedings. At least have the affidavits filed.
Yes, Lordship. I admit,
That's
Lordship.
minimum the court expects
Yes,
in a contempt petition, isn't it?
I admit, Lordship, I admit. And I apologize for that also.
Yes.
Hello.
Lordship, earlier it was respond number 1 only, Lordship. But in the meantime, he was transferred to another office, Lordship. Now, Mr. Akashdeep, Lordship, he is respond number 2. He is before your Lordship today.
Uh, it is Tamshir Ali's decision there? Mr. Goswami, you have it.
Citation.
Do you have a copy of Tamshir Ali?
My lord.
You have. Which paragraph is that chronological part?
Kindly, my lord, kindly come next page. Oh, directions. No. What?
Yes, I think para 14. All claims for payment of outstanding dues would be entertained, admitted. I think the guidelines were formulated in Jatin Pathak's case, right?
Lordship. But that part is here.
Where is
Just
that
later.
part?
Lordship, I kindly start from paragraph 5, Lordship. Paragraph 5.
Yes.
While disposing of the repetition, it was also ordered that the direction contained in the order should be adopted by the department in deciding all similar claims that may be pending before it. The directions are as follows. 1. Public Works Department of the State of Assam shall prepare a list of contractors in each of these divisions to whom money is admitted to be due on amount of the contract works performed whether under order of this court of 2 is important, Lordship. Such list will be prepared division wise in strict chronological order on the basis of the date on which payment is due.
Only thing, Mr. Nayak, where do you get it that you have to pay it as per the chronology? Because now we don't know when you will make these payments. Have you followed what I'm saying?
Yes, Lordship.
Because if he's entitled, it has to be released in favor of the petitioner in terms of the decision in Tamshir Ali. Now, which is that direction that these payments will be paid chronologically as and when the funds arrives or something? There must be something here.
Lordship, I'm finding that paragraph, Lordship. In my copy, it is.
Because I am trying to close it.
Yes.
If you can give it to me, then I can close this
Lordship,
contempt.
Lordship, it will take 1 minute, Lordship. In my copy, actually, it has been marked. This copy.
Because the guideline is issued in Jatin Pathak's case.
Yes, earlier it was Jatin Pathak, Lordship.
Subject, however, to the following conditions. Then comes these 3 conditions.
Lordship, may kindly see the last. Same is also disposed of in terms of this order, even otherwise also the writ petitions.
Where?
Dispose of. Paragraph 19, Lordship.
Yes.
It was just statement that it was decided in terms of Jatin Pathak.
Correct. So that's why I'm asking you.
Let me find out that specific line.
Where is that direction?
Yes. Lord.
That chronologically.
Yes, Lord. Let me find out that specific line.
If you can give me that, I can actually close this.
Lord, it will take 5 minutes, Lord.
The person is Mr.
He is Akashdeep, IAS. He is the Principal Secretary, BTC. Respond number 2.
I think we can release him then.
Yes, Lord. Yes.
I can, in the order, we will record his presence. He is impleaded later on.
Yes, initially it was R1 only. Subsequently, on his transfer, he has been impleaded, Lordship, as R2.
But the amended cost title has been submitted.
Yes, my Lord. Get to go here.
All right. Mr. Akashdeep.
Yes, my lord.
Yes, we have seen your affidavit. There is some clarification which I've asked your counsel. He is here to clarify. In the meantime, I'm going to take up the other matters. So you may be, you are released. All right. You may not
Much obliged.
stay connected in the video conferencing. I'll record your presence in the order. All right.
Thank you. Thank you, Lordship.
Lordship.
52.
Yes, 52. Dismissal. Heard.
You, Borua.
Before that, you say this matter was fixed today in the order column with the remark for dismissal in view of the fact that on the last occasion, i.e. 4/6/2025, there was no representation on behalf of the petitioner. However, today when the matter was called, MS.
You, Borua.
U. Borua, learned counsel for the petitioner, is present. Mr. N. Goswami, learned government counsel, is also present on behalf of the state respondent. In view of the appearance of the learned counsel appearing for the petitioner, relist for this matter is going to now come for what?
Admission.
Admission.
For admission in the usual course.
Obvious. Hey, please, your lordship. First of all, I am apologize for the last time.
This matter was fixed today in the order column with the remark for dismissal in view of the fact that on the last occasion, i.e. that is 4/6/2025, there was no representation on behalf of the petitioner. However, today when the matter is called MS.
Lordship, we are not able to trace the file loss.
What is your name?
CM Decca Lordship.
Please try and be mindful what is happening in the court. All right. MS?
CM Decca Lordship.
CM Decca.
Yes, ma'am.
CM Decca, learned counsel for the petitioner is present. Mr.
I've got 20 lakhs.
N. Goswami, learned state counsel for respondent number 2 and 3, and Mr. A. Bhattacharjee, learned standing counsel, revenue and disaster management are also present. In view of the, now this matter has to be listed for? In view of the appearance of learned counsel appearing for the petitioner, relist for admission in the usual course.
Bless us.
The issue here is as regards the
Fine.
appointment of the respondent number 3, sorry,
4 and
respondent
5.
number 4 and 5. And your contention is that they don't have the requisite qualification in as much as the recognition, it is not recognized or equivalent. And there cannot be any implied recognition.
Even if it is recognized also, others is not, as per the advertisement, is not eligible because only B, not equivalent any other qualification. He is not B, but equivalent to other qualification.
He admittedly B civil is a equivalent. It has
What
an
is not
equivalent
used in the advertisement?
Huh?
Only B has been used, my lord.
Under the advertisement.
And in the advertisement.
And what is the degree which the
Degree is, my lord, AB associate course, my lord.
R4 is A?
AB associate course, my lord. It is
AB.
AB associate course, my lord.
SO?
Associate course.
Associate course.
Which seems to be equivalent, but the advertisement only the
But
B.
are you admitting that it is equivalent to B civil or not?
No, my lord.
You are not admitting. And R5?
R5, my lord, is there only advertisement only for one post, my lord.
So
Then they have, my lord,
they have
appointed
appointed 2
2 persons.
posts.
That is, my lord.
Otherwise, R5 is a B civil.
Otherwise, regarding qualification, we are not disputing, my lord.
And Mr. Das is for R4.
Five.
R5.
5.
Mr. Das, you seem to be safe. If suppose R4 goes, then you are still there.
Yes,
Because one post.
Even if R5, 4 is there, I'll be there.
You will be there.
Because of the.
Now, assuming that this court finds that R4 is also qualified and this court doesn't interfere, then the next question immediately that will come is whether R5 could be appointed when the advertisement was admitted for one post.
First reason is, I have given that Sivananda's case. Even if it is, I am illegally appointed. Illegally, I have no hands in the thing in view of the affidavit filed. Because of the time lapse, 7 years, 8 months. After that, my lord, his service, my lord, if it is cancelled, my lord, set aside, it will be against public interest.
So these your appointments are of when?
2000 appointment is 2017.
2017.
9/17.
Page 32. 2017.
Yes.
Page
32.
Page 32. And these have been challenged when? 18.
18. Within the period, man.
Within
the period of 1 year.
And his position, their position, if your lordship kindly see page.
So his challenges within the so obviously it will be subject to the outcome of the writ petition.
Yes. No,
I am not on that, but what is the explanation that has come from the respondents? Who is the concerned respondent? Mr. Chutya, how you have appointed 2 persons when the advertisement was clearly for one?
paragraph 8, my lord, reading that, my lord, validity of the period, my lord.
In your written arguments,
Also, written argument.
yes.
The lord is looking for affidavit, my lord.
Okay, this is petitioner, this is yours. In affidavit, which page?
Is 56, my lord.
Page 56.
Regarding my lord, we have inquired to the my lord ministry, my lord. Ministry told us that the degree awarded by the Institute of Civil Engineers is a valid degree, my lord. First point, my lord.
1 second, page 56.
Regarding the validity of the my lord degree, my lord.
Yeah, that's
awarded by-
paragraph 9.
Paragraph 9, my lord. Annex of 5 is 63 is the letter.
Yes.
It has been specifically stated that those who obtain the degree up to 31/5/2013, they are valid, my lord. This is the first part, my lord. And the second part, my lord.
No, valid in the sense now,
They have, my lord, the persons or the students who admitted in the institution prior to 2013, my lord, their degree are recognized by the ministry, my lord.
by the ministry.
My lord.
But in your advertisement, you never said
The
equivalent.
It is only stated regarding the bachelor
We-
degree, but the degree is equivalent to BE.
But it is not specified equivalent.
That is correct.
Now, if tomorrow someone has that equivalent,
My lord.
he will not apply because he will not know
My lord,
that
it is-
whether you are going to accept the equivalent or not.
My lord.
Correct. So generally in the advertisement, that is why so and so or equivalent or whatever, it has to be candidly stated.
But the position of the petitioner in the merit list is 17. He has not made the party who are in the above the merit list.
That comes later.
My lord.
First come first. As far as the R4 is concerned,
Fine.
legally speaking, it's an admitted position that it was not there in the advertisement,
Fine.
right?
Right.
Now, as far as the R5 is concerned, admittedly, it was one post.
My lord. But during the validity of the select list, another post was vacant and he was appointed again.
Where have you,
But
now,
it was stated by
Paragraph 6 of the affidavit.
my lord.
of this affidavit?
My lord.
Yes.
Page 55. That the Department has to state that though in the advertisement dated 17 to 2017, it was mentioned that one post of assistant engineer was vacant. But due to the promotion of the incumbent from the assistant engineer to superintendent engineer, after creation of the post of superintendent, another post of assistant engineer became vacant. And the response number 4 and 5 were appointed against the two.
Do you have any law backing for this? Which is the authority you want to show that if suppose during the validity of the select list, during the pendency of the selection, if there is another post which has come vacant, if you can fill it up with the against the same advertisement, which was for one post. No, but that is also the second question. These are the two questions, if I am not wrong. First question is whether the degree of R4 can be accepted as a degree under the advertisement. That is the only question. Where this court will, if this court comes to finding yes, being in equivalent, this court can accept, then of course R4 stands. But suppose this court is this no, because the advertisement simply said BE civil, so it has to be only BE civil and nothing more. Because it is depriving others, Article 14 has to be also seen. You cannot ignore Article 14, right? Second question, because the moment that goes, then otherwise R5 can come. But suppose that doesn't go, then automatically for upholding the R5's appointment, this court then the question is, could you have appointed R5 against the advertisement which was meant for one post?
We have stated in our affidavit that during the.
Correct. So whether that is permissible, you all have given bulky written arguments and a various case laws. Now point out which is that case law which permits you to do this. Because I don't think anything more is required. These are the only two issues. This court can confine its arguments to this too, and of course this court will look into.
The position of
That's right. I was about to say that this court will keep that in mind.
For their purpose, we have submitted, my lord, the.
That this court will keep in mind, but nonetheless on merit, these are the two issues, isn't it? So where is that decision?
That issue, my lord.
Mr. Das, that decision perhaps would be also in your interest.
Well, that is there, but what I find, my lord, the position of law is very clear, according to me. If the advertised post is one, it has to be one. It cannot be.
Correct.
That is the
Correct.
position of.
Correct.
But what I am saying, because of the Sivananda case, it
That
says.
is, Mr. Das, I could have understood that case if suppose the writ petition had been filed on a later stage.
Even then,
Here you see, Mr. Das, if an illegality has been done, by efflux of time, it cannot be perpetuated.
No.
Because the appointment of respondent number 5 will always remain subject to the outcome of the writ petition.
No, that is not there, my lord. That order, there is
The order
no
need
stay
not
order.
be there. That is very.
In this cases of, in this case.
I will look into it,
yes.
Mr. Das.
The Lordship will
I will
look
surely
into-
look into it.
The Lordship will look into it.
I'll
It is
surely
there,
look into
even if it is in violation with law.
You
it
may
allows
just
some
read that
recourse.
paragraph.
Decision of the High Court was contrary to the paragraph 8. Candidates before the courts are agreed by the fact that as a result of application of cutoff marks in Viva was, they have been ousted from selection, though they would rank higher than many of the candidates who have been selected on consideration of aggregated marks in written. Relevant paragraph, my lord. Public authorities cannot take decisions of public interest by going against the sanctioned law, and without amending it, the decision must withstand the test of consistency, transparency, and predictability to avoid being termed as so-and-so. Legitimacy of expectation is to be established, and that same has violated article so-and-so. In terms of relief, it would be contrary to public interest to unseat the selected candidates after the lapse of more than 6 years. 6 years, since even
Let me
they.
see when that writ was filed, challenged. When was the writ filed?
That was challenged, but he continued.
No, when was the writ filed in that
18,
case?
18. In that case, yes.
In that case, yes.
That case, I'll have to find it out.
That is also
Bench of
important.
2 judges of this. It was filed
you are-
immediately. My lord.
You are R5, na?
Yes.
No, R5.
And your lordship will kindly see their status.
Which is the case that you are relying?
Sivananda. Sivananda. Judgment was 2023. Case proceeded in the year 2017. This was a case where pertains to district judge, district and session judge, including additional district judge. Method of appointment of third category stipulates that 25% of the post shall be filled up by direct recruitment from the bar. The paragraph 15, your lordship will kindly see, Supreme Court held that the decision
Wait,
taken by the High Court.
I'm just reading from 13.
Yes. From paragraph 55 onwards.
Paragraph
55 onwards. Rightly or wrongly, they continued, my lord. What should this court do? The question which now arise before the court is in regard to the relief which can be granted to the petitioner. Because voice marks was even recruitment process was admittedly wrong. The final and the selection process was also wrong. The final list of successful candidates was on 2017. Candidates who have been selected have been working as district and session judge for about 6 years. In the meantime, all the petitioners who are before the court have not functioned in judicial office. At this lapse of time, it may be difficult to direct either the unseating of the candidates who have performed their duties. Unseating them all this stage would be contrary to public interest since they have gained experience as judicial officers in the service of the state of Kerala. While the grievance of the petitioners is that if the aggregate marks in the written examinations and viva voice were taken into account, they would rank higher than 3 candidates who are respondents to these proceedings. Equally, we cannot lose sight of the fact that all the selected candidates are otherwise qualified for judicial office and have been working over a length of time. Unseating them would, besides being harsh, result in a situation where the higher judiciary would lose the services of duly qualified candidates who have gained experience over the last 6 years in the post of district judge. For the above reasons, we have come to the conclusion that it would not be possible to direct the inductions of the petitioners into the higher judicial service at the present stage. Many of the petitioners would have since joined the bar and would be in the active practice. It needs to be clarified that they are having failed to gain selections to the higher judiciary.
Mr. Das, there, of course, it is a very different matter.
Yes. Malad, even
Judicial
if it is
work.
Judicial work, but here also, Malad, they cannot come. Your Lordship will tell me, see, they are positioned in the in the list is, Malad, they have given
17.
in the paragraph.
17. Huh?
The petitioner number 117, the others are 15 and 13. It is not that they will get, even if I go, they will not get. And besides this,
what is the reply to that argument?
And besides this, my lord, the persons who are in between, they have not been made parties. Otherwise also. My lord, therefore.
But they will not be affected.
They will not be affected.
Because you see, this court is not going to direct appointment of the petitioners. That can't be.
That can't be. So petitioner in that case, my lord, in the higher judiciary case, they were entitled to be appointed. But because of the system appointment, that's a different
because it's a judicial work. Discharge of
my
judicial
lord,
duty.
also, the
Experience is important.
Yes.
Now these persons have been discharging judicial duties, passing judgments for so long years, and suddenly you say their appointment is wrong. what happens to those to the judgments that they have passed? You see, it may have a lot of
That
consequences.
public image in the society.
So
about the
therefore, but ultimately court held
You
that
see,
since he has been serving for
Mr.
6
Das,
years,
it is the discretion.
discretion.
It is the discretion, and in the facts of each case, the court may do. Because after this court comes to a clear finding that the appointment is illegal or wrong, it doesn't mean as a matter of course, because a person has put in 17 to 20 years, he will be allowed. That also can't be. In a rare cases, certainly exceptions can be made. And in this case, definitely it was an exceptional case.
Yes. that is
Correct.
Yes.
Judicial officer. It is definitely an
My lord,
exception.
Sivananda
So
case.
that is all right, but you cannot say that
But
that is
yes.
the law. That is an
That is
exception.
not the law. This is an
That's an
exception carved out.
which one can make. But it has to depend on the facts of each case. The years cannot be just the
True.
only parameter. That can't be.
Yes, I'm saying that.
Because then you all know once a writ petition is filed,
Unless
now
a
of
stay
course,
order is-
nowadays of course situation has changed. You
otherwise
will find
also-
writ petitions getting disposed of at the admission stage itself.
That is true. Otherwise also, my lord, it is not their case that if he goes, I come in.
That
So
he
that
can't.
is- that he-
That he cannot. It is not.
And the petitioner, it is the authority who has appointed him on the basis of his position in the select list. He was second.
But
and respondent
because of
number first.
non-joinder of the people who are above him,
Yes.
I don't think this writ
No, no.
petition can be non-suited.
No, I'm not saying that.
Correct,
But
because that can't be, because those are not
I'm
affected.
not saying that.
Tomorrow, of course, if this court passes an order whereby directly this court, and that is, I don't think that is his prayer for
it's
appointment.
not that. It's
Correct.
not that. It
That
is-
can't be, because
Yes.
then, of course, his writ petition.
Since they are not going to get any relief by
Correct.
ousting me, so therefore, my lord, after a gaps of about
Are
8
you trying to
years,
say that the petitioner is not an aggrieved person?
he's not a aggrieved person.
Therefore, this writ is not maintainable.
No, not me. Otherwise
In
also, yes,
short,
that-
you are trying to say that,
Yes,
isn't it?
he cannot be an aggrieved
So
person.
this is not a PIL.
Not a PR. It is not, a writ petition could have been filed in a sense that if I challenge his appointment, he goes, I come in.
Correct, correct.
That is
I've
not the
understood
case.
that.
That is not the case here. A vague writ petition.
And
can
his
be-
prayer number 2 to hold fresh interview. Why to hold fresh interview? There are people select
Because
above
if
you.
one post become vacant.
Huh?
Suppose if one post become vacant.
Then what about the people in the select
they will
list?
get right, other people will get right to apply for my.
No, then
Last
what
8 years,
interview?
he was doing, my lord.
You know,
Then what interview? They are already in the select list.
oh, my lord, to be frank, my lord, select list, I have not seen, my learned friend also seen.
But it is annexed.
My lord, this is not published, only they have been appointed. We come to know though, they are the first, second.
Without a select list being
Definitely,
published.
but this is not in published. Not in
Not
published.
published.
Not even they have annexed also in the
Select list
reply.
is not before this court.
No, my lord.
Then on what basis are you saying he's the serial number 17?
Paragraph 4 is the paragraph.
Paragraph 4 is different. Where is the select list?
They have stolen it from the records.
This is not published, my lord, not
When was it published?
only from the.
How can people be appointed without publishing a select list?
Not published.
Yeah, published, probably.
It was public. Hearing.
Secondly, what that Shivanon case, my lord, can be differentiated, because there is a procedural illegality. Here is a substantive illegality. Here only when after my lord holding of the my lord, advertisement, the process is going, they have make it that they have who are the 5 above, there were minimum marks 35 has to carry. So that has been challenged under my lord. This is a procedural illegality. Here is a substantive illegality, my lord. Because one post advertisement, the second post has been appointed. The advertisement is only BE. They are appointing a person
Arbitrariness.
equivalent to BE.
Arbitrariness is writ
Arbitrary,
large.
my lord. And secondly, making party to the is not necessary, my lord. Each affected party
No, that first they have to show that they have published.
My lord.
If they have not published, how will you make them a
I
party?
do not
How
know.
will you know who are they?
My lord.
And without publishing, how can they make appointments? This point was taken in your writ petition.
I did not find anyone.
My lord.
I'm looking into it.
My lord, not
No,
exactly.
because they have said in paragraph 4 that you are at serial number 17. What did you, where is your rejoinder?
In the rejoinder, my lord,
You see, the problem is that if you make arguments, then ultimately it is for the court to look into it and
Well-
give a judgment, because the court has to
my
author the judgment.
the publication of the select list, that has been not pilot in my repetition. That
Then
well,
it's published.
It is for the number he has shifted by the.
You have never disputed this.
They have never questioned
They not
this.
disputed that.
You have not questioned it.
On that ground, they could have obtained a stay order.
Yeah, this is the merit list of Viva Vosa. And now in the writ petition, you are seeking for holding interview. What about these people who are there? All right, if the R4 and 5 has gone, what about them?
no, my lord, they are not supposed to be affected, my lord. If affected.
No. If this court has to give you relief number 2 to direct the respondent KAC, particularly respondent number 2, to hold the fresh interview to the post of assistant engineer as per advertisement dated 17/2/17, including the subsequent vacant post of so and so. Huh? Your prayer is also slightly contrary. At one go, you're saying no, it should be one post, it should not be 2 posts. Then in your prayer only, you're saying now you hold fresh interview for 2 posts. Mrs.
No,
Orania, something is wrong.
My lord, if the first post
You
goes
see,
because of
this merit list, which they have already made amendments in paragraph 4, na? Paragraph 4 of their affidavit, and this merit list, which is there in the record, is very clear. Viva Vosa merit list held on 25/3/17. So when these people have already been selected after an interview and they have been placed higher than you, if tomorrow the relief that you are seeking is to be given, they will not get affected.
no, my lord.
Because today, if suppose we interfere with the appointment of 3 and 4, they will have a right. They will have a right. At least 2 of them will have a right from the top. If those 2 doesn't want it, the next 2 will have it.
My lord, basically our prayer is, my lord, the respondent number 4, my lord, not qualified. Respondent number 5, my lord.
First and
Beyond-
foremost, Mr. Sorania, you
My
have
lord.
to impress the court that the writ is maintainable, that you are an aggrieved person. That is your first condition precedent, which you must satisfy.
My
Because this
lord.
is a writ petition.
My lord, my lord.
How are you aggrieved?
My lord, my
What is your legal right?
lord. My argument would be, my lord, there is a Supreme Court judgment, not necessary if met anyone also, that he is representing the others. Suppose he is representing the others, my lord.
Representing whom?
No, there is a Supreme Court judgment.
No,
my
you are
lord.
representing whom here?
The others, my lord. If
Which others?
who are, my lord, is supposed to be affected, my
Which is the Supreme Court judgment?
Judgment. No, ইয়াতে দিয়া কোন that I have, my lord, the Bijoy Kumar Pandey in my lord list of cases, my lord.
What is it called?
What is it?
My lord, Bijoy Kumar Pandey did my head notice transparency and select list publication. In my lord,
Is
head note.
head note number 10.
B, my.
B.
My come on. One more, one serial number.
What is the citation?
Citation is by Bijoy Kumar Pandey, my lord. Versus Arvind Kumar Rai, 2013, 11 SCC 611.
Number 11, yes.
Cell number 11, my lord.
But you see, that will go against you. The publication of the select list is a crucial procedural step. In the absence of published select list, the question of appointment right does not arise. Non-publication implies no panel or list exists for consideration. Here they have given the list. They say it is published.
Only to know.
Where have you said that the select list is not published?
My lord, my lord, I'm coming to the paragraph, my lord.
You yourself have written paragraph 17 and 18, Mr. Soronia.
My
I'm
lord,
reading from your
paragraph
note.
17 and 18, my lord.
But you see what you have written. Again, 17 and 18. In your note.
My lord.
Please read your note.
Another post from a old mail.
Read that paragraph, that point 11 in your note.
My lord, my lord. The filling up an unadvertised post from an old married list.
This is your note, no? Yes. Number 11, that citation list.
My lord.
Vijay Kumar Pandey.
Vijay Kumar Pandey, my lord.
Para 17 and 18.
I'm reading by paragraph 17, my lord.
Read that part.
Even assuming that prepares.
No, Mr. Soronia. Your note. What you have written.
My lord.
Read this. This is what has been given to me. I don't know if you are having something else. Read against 11 what you have written.
Man, I've just wrote note, my lord, maybe something, but paragraph 17 and 18, my lord.
First you read your note.
My
We'll
lord.
go to that later. You read it is your note.
My lord, according to my note, my lord, filling an unadvertised post.
Huh? No, the publication of the select list. You read that. এখন পোৱা নাই নেকি? দেখাই দিয়ক এইটো দেখি।
My lord, publication select is a crucial procedural steps, man.
Read.
In the absence of a public select list, the question of appointment right does not arise. Non-publication implies no panel or list exists for consideration.
But this is not in your case. In your case, the list is published.
My lord, maybe they have published, but they have not published.
Come on.
My lord, this publishment, there is a file, my lord. If they can show, my lord, though I have not taken the ground, can they show, my lord?
You have to dispute it first. Have you said in your pleadings that the select list is not published? They have categorically said in paragraph 4. You have not said anything in your rejoinder. Now, how this court can't give on assuming things that no, because it is not there, it is not there. These are crucial facts. You must make your case.
That is correct, my
Then you want this court to apply Vijay Kumar Pandey. Your own note says. For your satisfaction, you want me to go to 17, I will go. But your own note, you have noted it for the assistance of this court. And you have said, isn't it?
My lord, maybe, my lord, I have not categorically made an amendment in my petition, but they have not published that select list, my lord. So if they have not published the select list, my lord, they cannot go for the other because my lord,
what is this if? Tell me. You have never disputed this. You have never pleaded this.
My lord.
Now at the hearing stage, after so many years, you can't simply say, no, they have not published. How can you say that? And especially when the record says otherwise. This is the list.
My lord, in their affidavit also, they have not stated that we have published, my lord. Only they are sending the position of the, my lord, petitioners.
Have you questioned it?
And
have you disputed it? That is the question I've been repeatedly asking you. Because you see, you have come before the court.
My lord.
You have to assert your right.
My lord.
What is your legal right? How are you aggrieved? If this list is not published, then of course,
my lord.
Appointing R4 and 3, you are affected. But if the list is published, you are at serial number much below. You don't bring in the others. And you are saying, no, you set aside and hold fresh interview. When the interview is already done, somebody else is on top of you. Those appointments, those people you are not saying are not qualified. In fact, R5 admittedly has that degree also.
R5, we are not questioning that again,
No,
only the section.
correct. So therefore, you see, even R4 goes, R5 will come in.
My lord, that's why we have, my lord.
And right
He is
now,
a-
in any event, you will not get anything.
That is right, my lord.
Even if we hold that R4 is not, R4, appointment of R4 is not valid, R5 will get it.
Then there will be a vacancy, they will get a chance to apply, my lord. That is why I will deprive.
No, but
Will
R5
deprive.
immediately get it, that R4. Is there 2 posts, 1 post is already, the advertisement was 1 post.
My lord.
But first and foremost is what is your right?
My lord, if the R4 goes, my lord, the R5 will be coming, my lord. Then there will be vacancy, my lord, substantial vacancy. For that, they have to go for advertisement,
That's what they will.
get a scope to.
No, no. This court is not going to give them any direction. This court will not give any directions.
Not, my lord,
They will do whatever they want to do with their vacancies.
but
This
court may
court
not,
will not-
my lord, court may not
Now,
give the direction, but even then, my lord, they have to go for
that-
fresh advertisement.
Mr. Chutia, which was that page where you wanted?
Even they have also not stated.
Paragraph 4, you said?
What's coming?
Page.
Right? What else?
54. The equivalent text to state that respondent number 4 and 5 have secured first and second position respectively on the basis of merit cum performance in the biography list, whereas the petitioner number 1 is in the 17th position, the petitioner number 3 in the 15th, petitioner number 4 in the 13th, and the petitioner 5 was in the 8th position. It is pertinent mentioned here that the petitioner number 2 has not participated in the biography list. The office of the particular department has no copies of the particular nor duly fit the forms of the same petitioner. There are 5 other successful candidates in the merit list above the petitioner number should show, and they were not included as respondent in the present meeting. That has not been replied by lot. There is no pleadings at all that the merit list was not published. When the merit list was published and notified in the notice board by lot, and that as there was no pleadings at all, my lord, so there is no question of controverting that statement. This is only a final statement made today. And we have filed the affidavit in 2021 stating all those things. And
Any reply filed to this
No,
affidavit?
in our affidavit, they have not filed any reply.
They have also not stated my category they have published, my lord.
We have
Mr.
given their
Sorania,
position. The
who has
position is
filed a
that-
writ petition?
My lord.
Who has to assert the right? It is your writ. You have to assert. You have to show your grievance, isn't it? If you plead, you will get the answers. And you don't file a reply to para 4. You could, in reply to para 4, you could have always filed a rejoinder, which you don't do. Yes.
Reply to petition.
I think we can conclude the hearing. Yes, Mr. Kayal, you are for R5, R4.
R7 lots.
R7 is also there.
AICT.
Oh, yes. What is the AICT's role?
We have been made party and we have clarified that since 31st May 2013, those institutions they have taken admission that they can apply for this government.
At that point, I'm not R4. Who is R4? Our appointment. It's difficult. Your appointment is difficult. Where is the advertisement? Page.
In this case, my lord, my learned senior,
21, my lord.
senior, my lord, MK Sudhir is appearing. He has some difficulties today. He could not come, my lord. So he will argue, but
He will argue means I was about to close. If you want
Yes.
him to argue, then I will post it on Tuesday or Wednesday.
Tuesday or Wednesday, your lordship. may-
Otherwise,
any,
the point.
Any date, my lord, your lordship may fix. But only one point I'd
Why
like to
did
put.
you not say before?
Well, no, your lordship has taken because all other matters may be over, my lord. Only one point, your
No,
lordship.
because the whole purpose was to finish this matter.
Yeah.
That is the only reason I looked into it also today before coming.
Actually, your lordship.
I was hoping I could start the dictation or close it at least.
Maybe fixed on Tuesday, my lord. My lord, only one.
Anyway,
point.
before that, where is which page?
Yeah.
Advertisement
Advertisement,
plus
page
advertisement.
21, page 21. Advertisement is clear, my lord. There is nothing to be disputed. Page 21.
Must be BE civil from a recognized institution.
Education qualification must be BE civil
Then
from
how-
recognized institution.
How can you subsequently
No.
appoint someone who has an equivalent? Where is it given? There can be so many more people, more candidates who might have an equivalent degree.
My lord, this point, my lord, it will be argued, but they have not
No,
said, my lord.
No, this, even if they don't say, I don't care. This is the law. How can it be?
No, my
This
lord,
is so many, it will
then
be
let it come
arbitrary,
Tuesday, my lord.
completely arbitrary. How can you appoint someone who doesn't have the qualification as mandated under the advertisement? Yes, you can relax. You have those powers. But that power has to be first exercised. There has to be a corrigendum to the advertisement saying that now you are ready to accept equivalent, number one. Now that there is a second post available, you are ready to, you have made it to 2 posts. Where are all that?
This point may be kept open, my lord, on Tuesday, your lordship.
Now I'll forget everything.
Otherwise, my lord, technical, my lord, extension is not, my lord, permissible.
What?
That, my lord, this is my lord, distance education mode, he has got that degree, my lord. So that is not
Mr.
part of
Saranya, on that I'm with you.
my lord.
But you are still not being able to convince the court that this writ petition is maintainable.
Regarding, my lord, non-maximum party. The husband is there, my lord. I have to misplace. I'll show you next time.
There cannot be any judgment contrary to that.
My lord.
You have to show, because the writ petition.
Is the vital part.
Huh?
Is the vital part.
Absolutely. This is, you can't. How can this court entertain a writ when you are not a person aggrieved?
Would have been a very good PI.
This, Mr. Pitya, you keep this with you for the time being. You give it to me on when? Tuesday? बहुत matters नहीं जाननी.
Advertisement of
Pitya, go for it. Pitya, next Thursday. Tuesday and a few matters have already been fixed. Thursday. You see, please give your ask your juniors to just give the names. You give everybody's names, huh? Low appearance of heard Mr. So-and-so Saranya has completed his arguments, and Mr. Bidas, the senior counsel, has also given his reply. Mr. Bidas, the senior counsel, representing the R5. Mr. J. Sutia, learned standing counsel KAC, representing respondent number 1 and 2, and Mr. Kayal, learned counsel, appearing for respondent number 7, has completed the reply. Mr. Pegu, learned counsel, appearing for respondent number 4, seeks posting of the further hearing on another date in order to so as to on the ground that the senior counsel, Mr. M.K. Chaudhary, who is leading the brief on behalf of respondent number 4, is not available in court today, or is due to personal difficulty, is not available in court today. Relist for further hearing on Thursday, such and such. Mr. Counsel is asked one of your junior to remind the court master on Wednesday about this matter.
My lord.
Otherwise, I will not read, I'll forget everything. Let me finish it on
My lord.
Thursday. You got it?
Yes, Lord. Take a photo of details.
Yes.
Lordship, in Tamsirali, Lordship, during the hearing of the case, Lordship, one affidavit was filed, as is, it appears in paragraph 13, Lordship. para 13, Shamsher Ali.
Yes.
As per the said affidavit, in the meeting, all the departments unanimously agreed to adopt the guidelines contained in the judgment and order dated 31/5/2005, passed in Jatin Pathak's case. Lordship, same statement is there in paragraph 12 also for C line. Now, if Lordship comes to paragraph 18,
Is this your book?
court's book, Lordship. Court number
Para 18.
Para 18. First, I've referred to paragraph 12 and 13, and now 18, Lordship.
Yes.
Since the government of Assam has agreed for disposal of the writ petitions in terms of their broad agreement to abide by the guidelines formulated in Jatin Pathak's case with the aforesaid terms and conditions, we need not answer the question formulated as to whether the forum under Article 226 of the Constitution of India is appropriate to adjudicate the claims relating to payment of contractual bills and whether the writ petitions are required to be entertained in such cases. In view of the broad agreement arrived at by and between the parties, we dispose of all the writ petitions in terms of the agreement. So one agreement was there that just guidelines in the Jatin Pathak's case will be followed. So full bench preferred not to enter into the issue that was referred to the full bench.
And that agreement in this disposed of in terms of that agreement.
Yes. Now, if Lordship comes to this Jatin Pathak case, Lordship.
Yes.
Guidelines is at the next page, Lordship.
Yes.
Lordship, we are
number 2 and 4.
2 and 4, Lordship. 2 and 4. 2 such list will be prepared division wise in strict chronological order. On the basis of the date on which payment is due.
The particular heads of accounts and against the division will be applied for discharge of the admitted dues
in the order in which the list is prepared and maintained. So these two are relevant, Lordship. 2 and
okay. We'll close the contempt.
My lord, it may be closed, but a direction may be given.
Huh?
A direction may be given within a time.
For what? Contempt court is not an executing court. Direction is already there. If we close the contempt, they have to do whatever is there. Affidavit con call. Affidavit. Ahi gol. I think I will use yours for the time being.
No, I have not used. Lordship has flagged this.
No, that is why. I said I'll use that for the time being because I have already underlined it. Heard Mr.
S. Abdullah.
Huh?
S. Abdullah.
S. Abdullah, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned counsel for the contemner number
1 and 2.
1 and 2. Stop. Pertinent that in view of the last order dated 2/6/2025, the contemner number that an affidavit has been filed today on behalf of the contemners. On behalf of the contemner number 2.
Filed day before yesterday.
Day before yesterday. Was filed on 5. No, 5 hoga na? 5/6/2025. On behalf of the contemner number 2. On behalf of the contemner number 2 and the contemner number 2, Mr.
Kasdi.
Shri Akashdeep, IAS, Principal Secretary, Bodoland Territorial Council, Pokrachar, Assam, 7-8. No, don't say all that. Principal Secretary, Bodoland Territorial Council, also join the hearing through remote virtual conference mode. Stop. By way of this petition, under Section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, and Contempt of Courts, Guwahati High Court. Rules 1977, the petitioner has the petitioner has drawn the attention of this, has brought to the notice of this court to the alleged willful and deliberate violation and or non-compliance of the order dated 13/5/2022 passed by this court in WPC number 3117/2022 by the contemners. Stop. Apt to reproduce the operating portion of the judgment in order dated 13/5/2022 passed by this court, which reads as under quote unquote paragraph 7. Quote unquote
Lordship, in my affidavit, this is paragraph 3, Lordship.
Wait.
Paragraph 7 of the.
Quote unquote paragraph 5, 6, and 7. In view of the fact that the aforesaid order was not complied by the respondents within the stipulated period of time, the instant contempt petition has been filed. It appears from the affidavit in opposition filed on behalf of the respondent contemner number 2 that in compliance of this court's order dated 13/5/2025, the BTC has already compiled a comprehensive list of liabilities under the Irrigation Department under SOPD BTC from 2010 to 2021 in terms of the decision passed by this court in the case of Tamsher Ali and others versus State of Assam and others, reported in 2008 volume 4 GLT 1 within bracket FB. And in the said consolidated list, the name of the petitioner has been placed at serial number 100. Apt to refer to paragraph 4 and 5, paragraph 4. I think 4 is sufficient.
4 is sufficient.
4 of the aforesaid affidavit, which reads as under quote unquote, paragraph 4, page 32. It appears that the petitioner is at serial number 100 in the list prepared in terms of the judgment passed in Tamsher Ali, and the dues of the petitioner as per the averments made in the said paragraph is stated to be released as per the aforementioned chronological order. In view of the fact that the No, it further appears that the respondents have already verified the claim of the petitioner as per the direction passed by this court and has also held the petitioner entitled. However, in view of the fact that the petitioner is situated at serial number 100 of the list, wherein persons above the petitioner are still to be paid their dues, the petitioner shall be the funds of the petitioner shall be released after the persons above him has been paid. It further appears that the aforesaid is also in terms of the direction given by this court in Jatin Pathak's case. In the case of Jatin Pathak versus State of Assam, reported in 2018, volume 3 GLT 438, based on which the full bench of this court has issued has passed the direction in Tamsher Ali case. Correct. That being so, it is absolutely clear that there has been no willful or deliberate disobedience of this court's order. Hence, nothing survives for adjudication in the instant contempt petition. Accordingly, the contempt petition stands closed.
Obliged.
এইখন তো আহি গৈছে, এইখন ঘূৰাই দিয়া আৰু এইখন পিছত court number. I'll ask him to return it to court 1.
Court 1.
Or you can ask your junior to take it tomorrow.
Yes, Lord. Lordship.
Disposed of.
তুমি সেইখন আজি নোপোৱা, তুমি কোড নাম্বাৰ